All right, we all set over there? Okay. So let's begin by calling the roll.
Good morning, Mr. Chairman. This is roll call for the Joint Judiciary Committee for September 18th. Senator Case? Senator Cooper? Senator Furphy? Senator Schuler? Representative Chestick? Representative Crago? Representative Haroldson? Representative Jennings?
Excused.
Representative Nemec? Representative Oakley? Representative Provenza?
Excused.
Representative Rodriguez-Williams? Here. Co-Chairman Landon? Here. Chairman Washut?
Here.
You have a quorum, Mr. Chairman.
Thank you. Well, good morning, everyone. Welcome to Joint Judiciary. I'm sure everyone has noticed the agenda is quite full. So a couple comments before we get started. I want to call your attention to the committee's rules on decorum. Copies of the decorum rules are located with hard copies of the agenda out in the vestibule there. We note these rules at the beginning of each meeting simply as a reminder that we expect everyone in the room to conduct themselves in a respectful manner. Our meetings are open to discussion of all viewpoints, and the rules of decorum are in place to ensure that everyone is allowed to make their point of view heard. But we want to be able to proceed without abusive treatment of any sort or any distracting behavior. So start off, please silence your cell phones so they don't ring during the meeting. I would invite you to take a moment to read through the decorum rules, but I'll highlight just a few things. Although it may seem awkward as a formality, speakers will address all their comments through the chair. So if your comment is, say, Mr. Chairman, I'll acknowledge you, and then you can make your statement. And if someone asks you a question, it was Mr. Chairman, Representative Rodriguez-Williams, and then you answer the question. So it's always through the chair. Do not have individual direct conversations with individual committee members. Comments need to be directed to the issue under discussion. Try to stay on point. If you wander, I will probably call you back on point, keep the meeting moving. Speakers will avoid personal criticisms, ridicule, or name calling directed at anyone else in attendance. Okay, we keep it respectful. For audience members, we expect you to refrain from any behavior that disrupts the orderly conduct of the meeting. Specifically, we prohibit speaking out when another person is talking, carrying on loud or distracting side conversations, shouting, clapping, booing in response to some speaker's comments. Our general guideline is simply that everyone conducts themselves in a civil and respectful manner, and if you keep that in mind, we should have no problem getting through today's agenda. Thank you. Mr. Co-Chairman, do you have any opening comments?
Thank you, Mr. Chairman. I just want to welcome everyone. Thank you for being here. We've got a very busy agenda. One of the great privileges of serving on this committee is that many of the things that we're going to deal with really do matter. And I look forward to learning from all of you on the committee and seeing where some of these issues go. I just wanted, for those who have never testified in front of a committee or maybe plan to stream in or are here in person, please understand that we're just people, just Wyoming people, and we're sitting up here. Please don't be nervous about coming in front of us. Most of these bills are the beginning, not the end. These are an opportunity for us to begin a policy discussion and see which of these bills will go forward into a session. Long ways to go on all of these, so let's learn together. As the co-chairman said, let's be good to each other and have a great day. Thank you.
Thank you. Can the roll reflect that Representative Jennings is here, please? Thank you. All right, our first order of business is Law Enforcement Issues Statewide Medical Examiner's Office. We have a bill draft prepared by the LSO. You want to walk us through that?
Yeah, Mr. Chairman, I can. 24 LSO 57, draft 0.6, statewide medical examiner. This is 2-01 in the online meeting materials. This is a bill the committee requested at its first meeting after reviewing the topic of cold cases, autopsies, and death investigations. It is based loosely on a similar law in Montana. This draft would establish a statewide medical examiner unit within the Department of Health. It would authorize 2 positions and the associated funding for this new unit. And the draft also separately provides funds in an amount to be determined for counties to assist with travel expenses and mileage for coroners in the performance of their duties. So page 2, in the Department of Health statutes, that's where these 2 new sections in the bill are created. Page 2, line 4, just creating the statewide medical examiner unit within the Department of Health. The director of the department must appoint a statewide chief medical examiner who serves at the director's pleasure and who must supervise the unit. Then on page 2, line 14, are the requirements for the chief medical examiner, as well as any deputy medical examiner. That person must be a Wyoming resident, must be a physician licensed to practice medicine in Wyoming, and must be board certified in forensic pathology. The staff comment on page 3 just notes some considerations for the committee for potential additional requirements that would be that may or could be imposed on these medical examiners. And that would be whether a medical examiner must post a bond similar to a county coroner, whether the medical examiner should be required to complete the basic coroner's course, and whether the medical examiner may maintain outside employment. Montana's law specifies that medical examiners must be free from undue personal, professional, or political influences as they objectively complete death investigations. And as the bill is drafted right now, as long as there is no interference, these examiners would be able to pursue outside work. Page 3, line 26 requires the Department of Health to provide administrative support and any necessary facilities for the medical examiners. Page 3, line 31, the chief medical examiner, with the approval of the department director, may hire deputy examiners subject to funding, and those deputy medical examiners must also meet the same requirements as the chief medical examiner. Then moving on to page 4, beginning on line 9, these are the required duties of this new medical examiner unit. So they must assist the Division of Criminal Investigation with death investigations upon request of the division. They must perform autopsies as requested by the Attorney General or as requested by a county coroner. They're required to consult with and assist the Wyoming Law Enforcement Academy in providing a basic coroner's course. And then upon request by a county coroner, conduct an investigation if the coroner suspects death to be a coroner's case. The unit, if asked to do this under that paragraph, would be able to take the action specified in 74201B, which includes examining a body, performing an autopsy, or any other reasonable procedure. And then if requested to investigate, the unit would be entitled to use county facilities in the county that request the autopsy or the death investigation. Moving on to page 5, this is line 9. Upon direction by the Department of Health director, provide educational opportunities for coroners, medical examiners, peace officers, and the Attorney General's office. Then the medical examiners must comply with all confidentiality requirements in 74105. That section provides for when and how or not photos, videos, and audio may be released. It requires certain reports like toxicology reports to be kept confidential. Then page 5, line 16, the medical examiners would be required to charge a reasonable fee for each autopsy, investigation, or inquest that a county coroner requests, as determined by Department of Health rule, except the fee cannot exceed the expenses and cost of that autopsy or investigation. And the fees would be credited to a special revenue account that would only be expended upon legislative appropriation. Page 6, line 4 are the powers of the medical examiner unit. Beginning on line 6, they can exercise the powers specified in 74201 through 74209. And those are the statutes that govern county coroners and provide for their authority. They may utilize county facilities for performing duties under this article upon approval by the county coroner. They may provide and receive compensation for services performed outside of the state, so long as doing so doesn't interfere with their duties required under this article. Then page 6, line 19, requires an annual report to this committee and to the governor. And then on page 7, from lines 1 through 12, is what's required to be included in that report. The number of autopsies, total expenditures, and the general work of this unit. The staff comment on the top of page 8 is just a reference to the statute concerning the prohibition on dissecting or mutilating a dead human body. On page 8, lines 18 to 20, just clarify that the medical examiners are exempt from that prohibition. Then page 9, lines 6 and 7, and then 10 and 11. In 74201, this concerns a coroner's investigation. That investigation may include the appointment of the statewide medical examiner. Then page 9, line 15, this is a new subsection in 74201 that provides that the county coroner may request the services of the unit in performing any of the actions specified in this article. If a county does make that request, they would be responsible for paying the expenses and costs of any investigation that the unit performs. Then moving on to page 10, lines 7 and 8 and 12 to 13. This inserts references to the new unit in terms of the Board of Coroner Standards cooperating and developing continuing education courses for coroners and post-commission cooperation with the unit. Page 10, lines 22 and 23, this is 32-212, which concerns the State Inspector of Mines and investigating fatal accidents. Just allows that State Inspector of Mines to request that the unit, the medical examiner unit, hold an inquest. Then page 11, line 11, this authorizes up to two full-time positions for the upcoming fiscal biennium for medical examiners. Page 11, line 20, there is a blank amount for an appropriation from the general fund to the Department of Health for funding those two positions. The staff comment on page 12 just notes a figure that the Department of Health provided to joint labor last year when joint labor was considering this topic. Of course, any amount is up for the committee's decision. Then page 12, beginning on line 26, this appropriates an amount that the committee would have to determine from the general fund to the Office of State Lands and Investments for distribution to counties for purposes of travel expenses and mileage for coroners in the performance of their duties. Page 13, line 4 specifies how the appropriation would be distributed. It would be 1/2 in each of the 2 fiscal years for the next fiscal biennium. The funds would be distributed in the proportion that the population of the county bears to the population of the entire state. And then distributions would be made on August 15th of each year. Page 13, line 16 is just a standard appropriation language that limits the funds only for this purpose and that they would revert at the end of the biennium. And then, Mr. Chairman, this draft, this would be effective July 1, 2024.
Thank you, Mr. Fuller. Committee, any questions for Mr. Fuller? Mr. Co-Chairman.
Thank you, Mr. Chairman. So, Mr. Fuller, a couple of things. Can you please remind the committee and me of the work that was done by the Labor and Health Committee? You alluded to the fact that it was taken up, I believe, last interim. Can you help us know where that ended up and what, how much that was considered?
Yep, Mr. Chairman, just at a very high level, I do believe they heard from the Department of Health on this topic. A short presentation of sorts at one of their meetings. I'm not sure there is a bill draft that came from that discussion.
Okay, just a quick follow-up, Mr. Chairman. So at the bottom of page 12, section 4, where we talk about the appropriation, and subsequently we talk about budget for the county coroners. Can you help me with that one? Brian, what, I guess I'm a little confused as to, would this bill require more travel by our county coroners? Is that why we consider an additional appropriation on that front?
Yep, Mr. Chairman, Chairman Landon, at the last meeting, there was, I believe, discussion about challenges that the county coroners faced with traveling to different places for autopsies, to either the necessary facilities or to get to where, you know, an autopsy or death investigation would be performed. And it was at the committee's direction that this separate appropriation be included in that bill.
Thanks for that reminder. Appreciate it.
Anything else for Mr. Fuller? Senator Cooper?
Mr. Fuller, page 10, line 17 and forward, this refers only to mining accidents, not any other type of industrial accidents. Is that correct?
Mr. Fuller?
Yep, Mr. Chairman, Senator Cooper, that's correct. This would only be for mine accidents that the state inspector would have jurisdiction over. And Mr. Chairman, I saw this more as a conforming amendment that it would include reference to the statewide unit, since the county coroner was mentioned, that the inspector could make a request of the coroner. If enacted as drafted, the state inspector could make the same request of this new unit.
Anything further, Mr. Fuller? Representative?
Thank you, Mr. Chairman. Just briefly, and this is probably throughout a lot of places in our statute, but when it says has to be a resident of Wyoming, would that preclude us hiring from out of state unless we had broader language, like a resident of Wyoming or become one upon hiring or something? Do you see any problem there?
Yeah, Mr. Chairman, Representative Oakley, I don't. I think this is pretty common. I think it would be if something, you know, narrower, you know, upon hiring, for example, or, you know, language that's used for, I don't remember if it's the county attorney or the district attorney, you know, that talks about shall be at the time of election, you know, so I think you would need narrower language if that was to be the case.
Okay, state agencies. We have state agencies in the room who wish to testify on this bill draft? Yeah, not yet. All right, well, let's get coroners up. Mr. Whips, Coroner Whips, no, others? Come to the table, introduce yourselves, and tell us what we need to know about this bill draft.
Good morning. My name is Brittany Nyman, and I'm the president of the Coroners Association. Is this better? As the association, we are not in favor of this bill. We did provide a survey, and as the association, we also provided a letter outlining the reasons why we do not support this. Primarily from a financial standpoint, it's never going to be a unit that's going to be able to self-sustain itself. It's not a self-sustaining unit. And I believe Coroner Ivy can speak to that a little bit more in depth.
So good morning. My name is Erin Ivy. I'm the coroner for Fremont County. I'm also the vice president of the Wyoming Coroners Association and a member of the Wyoming Board of Coroner Standards. So I'm representing the Wyoming Coroners Association in this aspect and our opposition to this bill. And I'm not sure if you're aware or have been made aware, and perhaps it's too old for most of you to know, but there has been it's called WISAC. It's the Wyoming Survey and Analysis Center out of UW. And back in 2007, they did a comparison of 3 medical legal death investigation systems for Wyoming. And they went through in detail, no bias, because they're the college. There's no bias on either side, whether it's DCI, Coroner's Office, Department of Health, and just went through to try and compare and contrast the 3 different systems and which ones were the most viable for Wyoming. And in this, the cost to the counties for their coroners, and I used an inflation rate based on the PC's price index inflation rate for the last, from 2007 to now. So just from a cost perspective, counties pay around $2.5 million for their coroner's offices. That includes autopsy, toxicology, histology, and all case investigations. It includes working with the families, our vehicle costs, really all aspects of operating costs for the coroner's office. A medical examiner system where the medical examiner is for consultation purposes, where we ask the medical examiner to perform an autopsy on behalf of the coroner, would cost the state around $3.5 million, recouping about $1 million in costs of autopsies, and that's at the high end of the cost of an autopsy. So I did the high end of everything just to kind of show you where we're at. So if we do approximately 500 autopsies in the state, give or take 20 autopsies here and there. But if we do 500 autopsies at the cost of $2,000 per autopsy, which is the high end of what we pay now, that's $1 million. So $2.5 million is left to be recouped by the state to put into one medical examiner's office. And we're looking at possibly 2. So that's what this bill proposes, is 2, a chief medical examiner who then appoints a deputy or multiple deputy medical examiners. So from a cost perspective, also the way it's worded in this bill is where there's an investigative role on the part of the medical examiner. So in this comparison back in 2007, with the investigative role, that number jumps up to $3.8 million that is incurred by the state, $1 million being recouped from the coroner's offices, and then not taking into account the payback that's going to be given to the coroners for travel. So I have no idea what that number looks like, but this is millions of dollars every year to ensure that we have 2 medical examiners in the state. According to the NAME standard, for every 250,000 people, there should be 2 medical examiners, and right now we have access to multiple. Albany County, Laramie County drive across the state border into Colorado, where they have access to 2, possibly 3 forensic pathologists. Fremont County, we employ our own forensic pathologist, and we do most of the cases for the western side of the state. So what you're looking at is a medical examiner system, or a medical examiner that's appointed, who's only taking about less than 2/3 or less, maybe half of the state's autopsies. So in recouping that money, now you're only looking at $500,000 instead of $1 million in revenue that would come back in, minus what you're putting back out to the coroners for travel. And this is a huge undertaking that is going to cost millions of dollars to the state, something that I'm not willing to go back and tell the people who elected me that we need when we have access to these facilities already. So just something to look at, the 2007 comparison of 3 medical legal death investigative systems for Wyoming. In reading through this bill, it was painfully, or not painfully, but it was obvious to most coroners who read through it that coroners were not, and medical examiners were not included in the drafting of this bill. I don't know who helped with it, but we would love to be able to assist in any way possible. I know there was a survey that was done, but that was done through our association as to who needs these services, who's not receiving these services, and what they're paying for the services. And I believe that the association provided that information to this committee. Anything else? from
Anything
me?
further?
I don't think so.
Questions for the witness? Representative Chesnick.
Oh, I'm sorry, I do have one more thing to add.
Go ahead, please.
The annual budget for the Fremont County Coroner's Office is around $450,000. 18% of my yearly total budget goes to autopsy. If we were to incorporate this medical examiner system, 55% of my budget would go to autopsy to recoup the state for their losses.
Can you explain why that cost increase?
If we were trying to recoup for the whole $3 million that the state would be paying, we would be paying close to $7,000 to $8,000 per autopsy.
I don't think that would be the intention, but thank you. Representative Chesnick.
Thank you, Mr. Chairman. This is for either one of you. I understand that you object to the bill on the basis of the cost of it, but I'm curious as to, is there an unmet need of some sort that this bill addresses? Or do you think, is there a problem with getting autopsies right now that this bill might help with, or does it not have any effect on your ability to have timely autopsies?
Coroner Ivy.
No, it does not have an effect on our ability to have timely autopsies. As I mentioned, we have a forensic pathologist on staff in Fremont County that serves the western half of the state, and within 24 hours, an autopsy can be performed.
Follow up.
Yes, follow-up. I understand that in Fremont County, you have in-house capacity for autopsies, but what about the rest of the state? Are there other places in the state that would benefit from having a state-provided medical examiner?
Mr. Chairman.
Coroner Ivy.
Mr. Chairman, in speaking with the other coroners, a lot of our major population cities are on borders or close to the border, close to Billings, close to Colorado, close to Nebraska, where within 35, 45 minutes drive, they are to their forensic pathologist. The only county that I can see that could benefit from a forensic pathologist would be kind of central, maybe Natrona County, Sweetwater County perhaps. I know Sweetwater County takes their autopsies to Colorado, and it's a lengthy, it's a drive for them to make that trip, but it is a one-day drive, and the autopsy is done the next day in most cases.
Thank you. Any further questions? I have one. So presently, when these county coroners transport a body to Colorado or Nebraska, who pays those costs?
The county.
Okay. All right. Thank you both for your testimony. Yeah. Anyone else wishing to speak to the committee on this bill draft? Please introduce yourself and tell us what we need to know.
Good morning, Mr. Chairman, members of the committee. I'm Jeremiah Riemann here on behalf of the Wyoming County Commissioners Association. I just brought an updated document of the one that initially I had submitted to the committee. I see that the one that's online is up to date. So if you have the online version, that is consistent with what is being passed out. Mr. Chairman, you asked us to do some research relative to the system in the state, and really this is our attempt to try and be responsive to you. As you can see in the color-coded area, We note the facilities that are being used by counties where they may be sending some of these autopsies, whether that's in-state or out-of-state. Included the average number of autopsies, the cost for those autopsies, and some general comments. And really appreciate the coroners across the state assisting in this endeavor, as well as providing you the information about the autopsy costs. There are two columns on the very far right side of this. The first one there is whether commissioners support the establishment of a statewide or regional medical examiner's office. And I'll just start by saying county commissioners are very deferential to the coroners across the state as a general purpose. But you can see that there is concern amongst commissioners that we have an issue to address. Yes, there are some experts within the state. Yes, there are some experts beyond our borders that we're utilizing. But I think as you've heard through previous work of this committee, some of those states have their own issues in obtaining medical examiners, forensic pathologists, and have begun to exclude use of those facilities. So commissioners are concerned that that could happen in the future. That said, and that's why you see there's a little note at the very bottom that although there may be some commissioners that are interested in the system, the type of system matters. They're not necessarily supportive of this particular legislation. Now, that's not a formal position of the association, but as a general poll in my survey of them, they're not particularly smitten by the way that this is crafted. And I'll get into that a little bit more here in a second. And part of that goes to the final column there that says, would your county be interested in converting or hosting its facilities for a statewide or a regional medical examiner office? And there are. You've heard Fremont County it has been very active in redeveloping its facilities and is interested in being a resource to other counties across the state. Bighorn County has invested significantly in its facilities and has a forensic pathologist and medical examiner that comes there, and they're pretty proud of that, and they're interested. There are some others, Campbell County, Teton County are some examples, and Sheridan County have all indicated they may be interested in that. Mr. Chairman, I do appreciate that this legislation was modeled off of the system that exists in Montana, and it's been a model that has worked for them. A couple of things about that. It is statewide, and it is not mandatory for counties to use those facilities or those personnel, but most of them do. I think the critical piece of that is that it's not mandatory. I think that you perhaps just heard, and a lot of people are concerned that they're going to be forced into a system that they're going to have to fund, even though it's being brought forward by the state. And I think that is ultimately problematic. I think from my perspective, what I've heard mostly from the commissioners is a desire for a partnership, for us to work hand in hand and see if we can't develop out some of these facilities. Could you incentivize a few counties to fully upgrade their facilities? I think we can discuss what that would look like. It shouldn't be all of the facilities, but perhaps 2, 3, 4 facilities across the state. Can we incentivize them to hire forensic pathologists and medical examiners in those counties in order to support a statewide system? I think that's what my members are perhaps more interested in than the state setting up an apparatus that we're fearful we're going to have to ultimately assume and pay the cost of. With that, Mr. Chairman, I'm happy to stand for questions, happy to work with you. Appreciate that you're taking this on. It is an important topic, and my members are interested in it continuing.
Questions from Mr. Raymond? So I have one, no one else's. So I guess, I look at your report here and we've got Teton County transporting their autopsies to Greeley, Fort Collins. It's a significant distance, significant cost. And one of the issues that we looked at was, that when a county spends the money in another state to hire a forensic pathologist to perform an autopsy, that money just leaves the state. Where if we have our own facility here in the state, that money gets recycled within our own economy. But I guess my biggest question is, if we already have forensic pathologists resident in Wyoming, why don't more of the counties utilize those services as opposed to taking their money out of state?
Mr. Chairman, great question. And I think that what I heard from my members is a desire to spend those dollars locally and invest them here. I think we're dealing with a system that is historic, right? There are a number of counties. Teton County is not the best example in this, but where they have developed relationships with particular offices to perform these services. They can get it done timely. It's responsive to them. They've got relationships. I heard that from like a Niobrara County, really appreciates the services that they receive in Nebraska and want to continue that. Now, well, that would continue into infinitum. If there's a change in coroner, I don't know. But I think that your ultimate purpose here in trying to incentivize use of Wyoming-based individuals is a good one, and one that the commissioners support, and certainly one that the Teton County commissioners expressed to me that they would support trying to move towards that system rather than transporting that distance. Mr. Chairman, as an aside to the conversation, I heard the question about a resident of Wyoming. I don't know where to land on that, but I'll say that I heard at least in one instance, the personnel that they're getting comes in from Florida, enjoys the community, enjoys the work, comes in for a period of time, does it, and then ultimately leaves. If you went with this bill, that might preclude that individual from serving that county under that capacity, but that's just an interesting aside that I found in this work.
Representative Oakley.
Thank you, Mr. Chairman. And Mr. Riemann, was there any discussion on this? Did you hear anything from, county attorneys, district attorneys, or anything as far as availability to testify as an expert witness? I know that's something that we started struggling with, and then we got lucky in Fremont County by having basically a retired, a really awesome expert moved to Lander, but it wasn't recruiting efforts. But so we have that now, but in all the other, the counties, when you're going out of state and then they say, we don't want to come testify. I think that's possibly one of the things, again, the more connected they are with Wyoming or something would be basically then the availability to continue to participate if necessary.
Mr. Riemann.
Mr. Chairman, Representative Oakley, I didn't have that conversation. It never came up. That's not to say it doesn't exist. It just didn't come up. I didn't ask that question, but I'm happy to try and dig a little deeper.
Representative Harrelson.
Thank you, Mr. Chairman. Mr. Raymond, real quick, a couple questions, I guess. Have we, obviously the concern is that at some point in time, we may not be able to bring these cases outside the state, and that door may close. Have we seen that happen yet?
Mr. Riemann.
Mr. Chairman, Representative Harrelson, it is my understanding that there's at least one state that has begun to contract. I want to say that it's Utah, but don't hold me to that. But I believe we have seen that happen.
I'm seeing heads nodding behind you, so. Okay.
Follow up.
Thank you very much, Mr. Chairman, for the follow-up. The second question is, obviously we see Lander on this list, but then we see Teton County bringing all 45,000 bodies to Colorado. So I just was just checking.
Mr. Chairman, I will update that figure.
Mr. Riemann?
We're having an issue in Teton. Yeah, I was gonna say. Sorry, I just had to bring some comedy into Monday morning, guys.
Mr. Chairman, as you can see, there is a note there. They do take some of their cases to Fremont County. It's in the fourth column over, so, and they may be doing more of that now.
Mr. Riemann, do we know how old this retired pathologist is in Lander and how many more years that individual might be serving that community?
Mr. Chairman, I don't know that answer. I'm certain that there's somebody behind me that could.
Yeah, come on up.
Thank you. Further questions? Representative Oakley.
Thank you, Mr. Chairman. I just, Representative Chestick, and I noticed the one in our materials seemed to be right, and Teton was 15, not 45,000. The one that we just got handed out to us has some wrong numbers on there, but the one that was originally in your packet, I think is right.
Mr. Chairman, I'm worried more about Washakie County than I am Teton County.
So, Mr.
Deputy
Chairman, I
Coroner
would
Ivey.
like to answer that question. Any better? Okay, Mr. Chairman, I would be better able to answer that question. Dr. Frost retired from San Antonio, Texas, and it was with some recruiting that we got him to Fremont County. He originally was looking at Sheridan County, so we were grateful to get him to Fremont County. But he is 65. He plans to do this until he can't anymore. As we've seen with Dr. Thorpen, it was well into his 80s that he was able to still perform this type of work with the correct autopsy assistance or pathology assistance. So in Fremont County, all of my deputies are also trained pathology assistants. We all are autopsy technicians. Mr. Chairman, in response to the question about has any county attorneys reached out in regards to testimony from out-of-state pathology, yes, to my office they have. I've spoken with the Bighorn County attorney whose concern was serving subpoenas to locum tenens who fly in from Florida, who may come from out of state, serving them with a subpoena and then getting them back for testimony and how much that was going to cost their county for that testimony, because they are testifying as an expert witness and having to pay their travel costs for that. So there was a huge concern. What the conditions that we came to is that if Bighorn County had a homicide, that their coroner would transport the body to Fremont County, where our pathologist would conduct that postmortem examination. So ones that were likely to go to court.
Thank you.
Also,
Sometimes don't we not know whether it's a homicide or not until after that examination?
so oftentimes when you've got a gunshot wound that's from a distance, it is pretty obvious on scene that this person did not do that to themselves. So we can tell from our scene investigation whether or not an autopsy is going to be necessary. That's the coroner's job, is to do an investigation and to determine whether or not an autopsy is necessary in these cases. So oftentimes, the majority of autopsies are medical autopsies. It's one natural cause versus another because we can't see at the scene what type of natural event took place, whether it's an abdominal aortic aneurysm, a stroke, a heart attack, or some other underlying disease that we can't see. That would be a case for an autopsy. Homicides are always autopsied, even though, because we're collecting trace evidence and we have law enforcement present at those to help collect any of the specimens that they would want, to include sexual assault kits, trace evidence, hairs, fibers, things like that. Also, the overdose versus natural It's very difficult to tell on scene whether somebody accidentally overdosed or intentionally overdosed. So an autopsy may be necessary in those cases. So, but a vehicular crash doesn't necessarily need an autopsy. Any layperson can see that this is blunt force injuries due to a vehicle crash. So there's a lot of cases that don't require autopsy. Only about 20 to 30% of normal coroner cases are autopsied. So for the question about Teton County, Mr. Chairman, is Teton County brings all of their autopsies to Fremont County. So they're not traveling across the state to Fort Collins. Also, Sublette County is strictly using Fremont County. And we were contacted recently by Uinta County for autopsy there. The only state that I'm aware of that has not taken autopsy cases for the state of Wyoming is Utah, but I've been with the coroner's office for a little over 20 years, and I don't know that they have ever taken coroner cases from Wyoming.
So just a quick question. If you're in the blessed position that Natrona County was years ago when we had Dr. Thorpen, that our bodies didn't have to leave. We had our expert right there in the county, easy to testify and all that. If your resident pathologist were to retire, or otherwise become unavailable, would you have more interest in this type of approach?
I think we would try at a county level to find a replacement instead of having it the oversight of the state.
So if Fremont County were to hire a pathologist on a salary basis, or are you going to pay them on a contract basis? I'm trying to figure out how you're going to attract we have a nationwide shortage in pathologists. You want to attract one to Fremont County to do your autopsies. You're just going to pay them per autopsy, or are you going to offer them full salary?
So it's, as it stands now, it's per autopsy. And there are more retiring forensic pathologists than there are incoming forensic pathologists. Most of the retiring forensic pathologists are not looking to get out of pathology altogether. They're looking to retire and do a minimal amount of casework. They're still wanting to stay accredited. They're wanting to go to the courses that are offered either through NAME or through the NAME, which is the National Association of Medical Examiners. They're wanting to keep that accreditation. And so they have to perform so many autopsies per year to be able to keep that accreditation. In Fremont County and the western part of the state, we give them that opportunity to maintain the accreditation, perform a minimal amount of autopsies. We're performing approximately 100 autopsies per year, and have their insurance and Wyoming license paid for.
Thank you. Mr. Co-Chairman.
Mr. Chairman, I'm just trying to get my arms around. When I read this bill, I thought that it would be complimentary, but apparently it's not. And I can tell that Fremont County feels like it's got things handled. Wonderful. That's great. But I see 14 other counties who have expressed that they think this might be a good idea. Why is that? Is it just cost? I'm trying to get arms around why there's so much pushback here with regard to this being a potentially better system. If money wasn't the object, why is it that the other counties are interested in what this might bring?
In my opinion, Mr. Chairman, it is the availability of autopsy. The way that this bill is written, I believe, has too much overreach, is not able to distinguish. The coroner's office, the medical examiner, is supposed to be the unbiased third party to law enforcement, to families, to the attorney's office. We're supposed to be that unbiased third party that speaks to the truth of the matter. If this is under DCI, and DCI can request these autopsies, are these pathologists truly unbiased?
No, I think you misread the bill. The bill draft makes this a request from either the Attorney General, okay, or, but it's going to be housed in the Department of Health. So it's available upon request to the county coroner, or it's available when, in those rare cases where the Wyoming Attorney General feels compelled to have the medical examiner involved. But for the most part, this is going to be on a request basis by the county.
Mr. Chairman, could I respond to that? Mr. Chairman, I certainly read it the same way that you do, that this is a voluntary system that you're standing up. I think where I heard the angst amongst my members, and that even includes the 14 or so that may have said, yes, they're interested in a statewide or regional approach, is that you're standing up a new state unit that's going to have costs associated with that. And who's going to bear the brunt of those costs? Is that ultimately going to be rolling down here? I think you heard concern earlier from the coroner that she's looking at the overall cost of it and saying, okay, now here's my per autopsy case, even though that may not have been your intent, that is a concern that exists out there. And I think that's why my members were more interested in, could we build a model that was incentive-based, that would be a partnership between the state saying that this is a priority with us, and would drive a few counties towards building the appropriate facilities and getting the personnel, not just retired personnel, but new crop in there, because you just heard there are people that are leaving more than are coming in. So we need to be able to build our base. And so I think there are commissioners very interested in that. I think that does a number of things. If we move towards an incentive-based model, it allows counties to continue to show leadership in this space. You've heard from a county that is trying to really step up its game and change its trajectory, as well as other parts of the state. It also helps to avoid some of that state versus county confusion, who's in the leadership role here, and the like. It eliminates creating a whole state unit. And I think, frankly, what I heard from my members is they felt that it was a better investment of the state's resources to move towards that incentive-based model. It could be a grant program through the Department of Health as you're trying to push here. It can't be for everybody. It has to be for a small subset, whatever you're trying to drive for, 2, 3, 4 facilities at most, and ultimately help us achieve our mutual goals here, because the counties are interested in doing something, or at least the commissioners are.
Thank you very much. Is there anyone in the room wishing to testify in favor of this bill draft?
Mr. Chairman,
Yes.
we also have the Department of Health online, if you'd like to bring them in.
Mr. Chairman, before I step down, power of technology, I was able to get you updated numbers. Teton County's average is 10 to 20, and Washakie County's is 10 to 15.
Anybody in the room wishing to testify in favor of the bill draft? All right, let's bring in Department of Health then.
Yes, good morning, Mr. Chairman. Can you hear me?
I can. Please introduce yourself and to everyone in the room and tell us what we need to hear.
Thank you, Mr. Chairman. Members of the committee, my name is Franz Fuchs. I'm a policy analyst with the Department of Health. Recognizing that you all have a very busy agenda, I'm just here to answer any questions we had on, or you might have had on the slide deck that we put together for joint labor last year. I'm happy to go over that model if you like, but we also have a couple tweaks to the bill. It's just up to your direction, sir.
Why don't you give us a quick overview where you left off with labor and health?
Sure, Mr. Chairman, members of the committee. Department of Health was asked to do the analysis by the Coroners Association and the Chairman of Joint Labor on what it would take to build a state medical examiner's office. We were looking at the volume of around 400 to 500 autopsies per year. And the model we came up with looked at travel time. As you all know, geography is a very significant facet of the state. And in order to try to maximize the efficiency and reduce the wait times that people would have to, or counties would have to wait for autopsies, our recommendation was that there would be 2 medical examiners located in Casper. And the central location was basically the most efficient place to do that work around the state. And then those medical examiners would basically travel to local county facilities and do the work at those morgues where the facilities are available. At the end of the day, our recommendation was for 2 forensic pathologists. But we also recommended some administrative support. So 2 autopsy technicians and administrative specialist. And our total recommended budget for this project, should we be asked to do this, would be about $1 million a year. That was the overview we presented joint labor. Again, the Department of Health did not ask for this bill. We just did the analysis as requested.
Thank you. Any questions for the witness? Senator Schuler.
Thank you, Mr. Chairman. Mr. Fuchs, just again, thank you for testifying. I'm just wondering, the way the bill draft is right now, do you think this would preclude counties from having the option of still going to out of state to their forensic pathologist of choice? Or, the way I read it, it just says the coroner may request the services of the statewide medical examiner, that they don't have to. But I don't know, maybe I'm reading it wrong. Maybe there's something in there that precludes them from being able to still go out of state. So I don't know if that was the tweak you were, interested in adding, or an amendment or whatever, but if you could just clarify that.
Mr. Chairman, Senator Schuler, we did not see anything that would preclude counties from taking their business elsewhere. The tweak we looked at was there's page 4, line 3, talks about how the deputy medical examiner would have to be in a separate county. And just from efficiency purposes, our recommendation was that they be both based in Natrona County to be able to reach around the state, and that was the most efficient option. So that statutory language there would preclude that efficiency. That was our main tweak, as well as potentially including in Title 35. There's a death registration section. There may be the will of the committee to add the medical examiner in that 35-1-418, but that's just a conforming amendment. So those are the 2 changes that we had in mind.
Sir, around the country, there have been some horror stories of failings within the coroner system. Did the Department of Health analysis take into account any of those shortcomings that have occurred in other states?
Mr. Chairman, we did not look at other states specifically. I think our estimate of the salary was based on the shortage issue with the forensic pathologists are in very, very short supply, as everyone knows. So that's why our salary estimate of $280,000 per year, that may be even low at this point, given the inflation that's occurred since COVID. But we really took it from that perspective.
All right. Thank you. Any further questions? Mr. Co-Chairman.
Thank you, Mr. Chairman. Not to belabor, but Mr. Fuchs, I guess that begs the question, what's on the horizon? Maybe Wyoming's doing fine under the current system, taking many of our autopsies out of state. But, I'm just wondering what you're hearing in the pipeline out there on this front. Are other states going to continue to be able to accept what we're bringing? Which way is the wind blowing?
Mr. Chairman, all the information that we got on that last year was from the Coroners Association. And my understanding is the problem we're trying to solve with this state role is really that availability issue that you've all discussed already. There's the idea that there's one forensic pathologist in Sheridan that's done the lion's share of a lot of the work in some of the northern part of the state, and he may be very close to retirement. There was concern expressed to us that other states may start locking out Wyoming from autopsies. I think this was all sort of looking at the future and looking at availability in the future, but I don't think we heard any concerns about the right now. But all our information came from the Coroners Association on this particular topic.
Mr. Co-Chairman.
Thank you.
Chris, anybody else in Zoom world?
Mr. Chairman, we also have Dr. Harness from the Board of Coroner Standards online.
Okay, bring him in, please. Doctor, can you hear us? Is he there?
Mr. Chairman, he is online. He just needs to unmute his mic and turn on his video.
Can you unmute your mic, please, Doctor? We can't hear you. Okay, unfortunately, I don't think we're going to be able to take that testimony. Anyone else in the room eager to testify on this bill draft? Seeing. Briefly.
Me and this microphone don't get along. I was asked by the director of the Board of Coroner Standards to just give their opinion as to the bill. One of the issues was the setting up the unit to work with the Board of Coroner Standards and then also work with the Wyoming Law Enforcement Academy to establish training. And it was a question that was brought up as why not just add them to the Board of Coroner Standards instead of making 3 entities work together? Why not give them just a seat at the board and create another position on the Board of Coroner Standards for that pathologist? So the Board of Coroner Standards already has a board-certified forensic pathologist on the board, but there could be an additional position added for the state medical examiner should one be appointed.
Thank you.
you.
Questions? Seeing none, thank you very much. With that, I'm going to close public comment on the 24 LSO 0057. Committee, what is your preference? Seeing no motion, we're going to put the bill aside. Be done with this bill draft. All right. That takes us to 9:30 and judicial branch topics. 24 LSO 63. You want to walk us through the bill draft?
So, Mr. Chairman, if you're okay with it, I'd walk through both 63 and 62.
That'd be fine.
These were 2 bills that the committee requested after hearing from the courts on judge and court security. So this first draft, 24 LSO 63, this is draft 0.53-01 in the meeting materials. This is the first draft of 2 concerning a criminal offense related to judge security. And this draft amends the current offense that's in statute of influencing, intimidating, or impeding jurors, witnesses, and officers to clarify that judges are covered under that offense. The staff comment just notes that the entirety of 65305 is included. Subsection B on page 2, line 19 wouldn't be included in any final version. I just included that so the committee would know what the penalty is. So page 2, line 16 in 65305A, simply inserting the word judge as an object of that offense. And then page 2, line 25 is a definition of judge for purposes of this offense. And it's currently drafted. It includes a Supreme Court justice, a district judge, circuit judge, chancery judge, or an immediate family member. The staff comment on page 3 just notes for the committee's consideration whether family members should be included, and if so, how that should be defined, whether federal judges should be included or specified. With them, though, Mr. Chairman, I would note that I think 2 federal statutes, is 18 U.S.C. 115 and 1503, would provide similar protection under federal law to federal judges. The next point for consideration is whether district court commissioners, circuit court magistrates, or municipal judges should be included, and then whether judges needed to be defined. And this was so the language on page 4 was in response, I believe, to committee discussion in April, and it just inserts Supreme Court justice, district court judge, circuit court judge, or chancery court judge right in 65305A. So that's an alternate version of that. And Mr. Chairman, I can proceed how you'd like. I can hold for questions now, or I can, if you're, with your permission, I'd walk through 62 as well.
Let's see if there are any questions specific to 63 first. Any questions for Mr. Fuller? Representative? No. Nima?
Thank you, Mr. Commissioner, or Mr. Chairman. Wouldn't court commissioner or magistrate be included under officers of the court?
Mr. Fuller?
Yeah, Mr. Chairman, Representative Nemec, I think that was the question that brought about this bill draft, is what does officer mean? And I think in response to that, that's why the committee asked for judge to be included. And I think if you include judge, certainly up for the committee's consideration, but whether, how that exactly that should be defined and who should be included in the scope of that definition.
All right, you want to take us into 64?
Yep. So Mr. Chairman, 24 LSO 62.4, this is 3-02. Similar concept. This draft just creates a separate statutory section concerning judges. So on page 2, there are definitions. First, a family member, defined as parent, spouse, sibling, or child, and then judge. Similar to the previous draft, it would start off with a Supreme Court justice, district judge, circuit judge, and chancery judge. The staff comment on page 2 just notes the scope of the definition of family member. That would be a question for the committee and includes examples of what other states have done in that regard. And then next would be, again, the question of the scope of the definition of the word judge. The penalty on page 3 would be imprisonment for up to 10 years, a fine up to $5,000 or both. If by force or threats, the person attempts to influence, intimidate, impede, or retaliate against a judge or a family member of the judge in the discharge of the judge's duty. The penalty is the same as the first draft, and that would be another consideration for the committee, whether that penalty should remain the same or different. With that, Mr. Chairman, I stand for questions.
Thank you, Mr. Fuller. Any questions for Mr. Fuller on either? Representative Chestic.
Thank you, Mr. Chairman. Mr. Fuller, are these intended to be tandem bills or one or the other? I mean, do you need both of them, or will one of them do?
Mr. Fuller.
Yep, Mr. Chairman, Representative Chestic, I think I would imagine that the committee would want to pick one of these bills and not proceed both. I think both would be duplicative.
Further questions, Mr. Fuller? Nothing? All right. Somebody from the judicial branch wish to chime in on either of these? Or both? Mr. Justice? Welcome back to Judiciary.
Thank you. Mr. Chairman, representatives of the Judiciary, I be happy, kind of.
Can we have you state your name for the record?
Yes, and I'm here in two roles, as a justice for the Wyoming Supreme Court, but probably more importantly as the chair of the Court Security Commission. It's a statewide commission. We would, first of all, I want to thank you for this draft bill. This is in response for my testimony last time that we spoke. We certainly continue to be in favor of these bills. I guess I'll leave it up to the policy decision-making of the legislature to decide how to approach this. My personal preference would be to have the separate bill that specifically sets out judges rather than lumping them in with jurors. But I think either one kind of addresses the concerns we have. I certainly would be happy to address any questions you may have on that issue. I brought with me Judge Bartlett and Judge Bush from up northeast of Wyoming, and they have some personal experiences that they have encountered just recently with respect to threats, and so I would defer to their comments. And with that, I don't have anything further, Mr. Chairman, unless you have any questions.
Any questions for Justice Finn? For Mr. Co-Chairman?
Just a quick clarification, Your Honor. Thank you for being here with us today. We really appreciate it. So I thought I heard you indicate that your preference would be that maybe we take both of these up.
No, I don't think it's necessary that you take both of them. I think they do overlap, but my preference is the separate bill that specifically sets forth that it's against the law to intimidate a judge. The other one is, if you recall, when we spoke last time, the juror tampering, these amendments would probably address those issues, but I don't think as explicitly as the separate bill. So, but that's, I have to walk a fine line of being a Supreme Court justice with respect to how far I go with policy. And I defer to the legislative body to determine those policy issues. I think the one that explicitly says you won't intimidate judges very clearly addresses the concern that I raised.
Appreciate that. Thank you.
Anything further? Representative Craigle?
Thank you, Mr. Chairman. Justice Fenton, so I guess maybe just if we could elaborate a little bit more on why you think there's a benefit of laying out a separate statute for the, intimidation or threats of a judge versus rolling it into the current statute. I mean, I could see a situation where, the current statute really almost deals case by case. Like you could read that to say, well, it's only gonna qualify as a crime if you're threatening a judge in relation to your own case versus threatening a judge generally, showing up at their house and screaming at them or walking around with a gun outside their house. So that I could see is one benefit of having the separate one, but I also see benefits of rolling it in together to keep it all in one place where we're treating the system as a whole. And to that, I guess I'd just like your comments, and then I have a follow-up question to that as well.
Justice Finn?
Mr. Chairman, Representative Craigle, that's exactly why I prefer the separate one, is because a lot of times the threats are not specific to a specific case, and just having it broader and very specific with judges, I think is my preference. It's not a strong preference, but that's is exactly the logic behind it, Representative Craigle.
Follow up.
Thank you, Mr. Chairman. So then that leads me to my next question, which has to do with the system as a whole. And, I'm not sure so I look at the statute, there's a couple other entities or groups that are involved in the criminal justice system. There's a group of them sitting right back over here, and that's our clerks. And then it's also our county attorneys. And a lot of this happens in criminal cases in my experience, but we're talking about our county attorneys, we're talking about our public defenders. And is there any way we can adapt the bill draft to cover them as well? And would the court system, would the judicial system be opposed to looking at that as well?
Justice Finn?
Mr. Chairman, Representative Craigle, absolutely. They're facing some of the same issues, and I think it would be appropriate to expand the bill to include other participants in the process.
Representative Oakley?
Thank you, Mr. Chairman. Justice Finn, so I guess my thoughts on this, the only difference right now that I can see, correct me if I'm wrong, is that we've added or retaliate. Other than that, it's identical language. But I know we've discussed this, and I like kind of what Representative Craigle said, which then perhaps we tailor the one that's a standalone, include more of, instead of kind of conceptually going, okay, this one's about intimidating jurors and witnesses and trying to influence them. That's kind of what I see, maybe what the current statute has. This one, then going more specifically, and perhaps even doing some wordsmithing on what we're really trying to get to as far as threatening, intimidating, retaliating, or whatever against the people who actively are involved in the criminal justice system, meaning prosecutors, defense attorneys, judges, clerks. You know, conceptually, I mean, and because right now, I just feel like maybe we can do some wordsmithing and go with that. That would, I guess, be my preference. Right now, we've just added or retaliate, and literally, other than that, it's the exact same statute. So maybe we need to want to get exactly what conduct we're trying to prohibit and against whom, and then keep it as a separate. I guess maybe that's my thought.
Justice Finn, any response to that?
Mr. Chairman, Representative Oakley, that's a tougher question for me to answer, because many of the instances we have are not necessarily relate to a specific action or case. We have mentally ill people showing up on judges' doorsteps. We have disgruntled parties in domestic relations. And so I think that the language, it's a real challenge to have it narrow enough to be an appropriate statute, but broad enough to kind of cover some of this behavior that we're concerned about. I don't have a suggestion for you other than I think the retaliation broadens it a little bit and addresses it better. And also the separate statute sort of broadens the instances where we're not just talking about a specific case or a jury trial or a criminal trial. And I know that the statute doesn't limit it to that, but this kind of separates that, because many of the instances, in fact, most of the instances we have are not in relation to a specific jury trial that's going on. It's broader than that. So I don't have a more detailed answer than that, other than I think that this separate statute deals with it better. And with respect to including other participants or broadening out who is protected by this, I certainly don't have any objection at all. I think that's a great suggestion. I hope that answers your question. I know it's a bit of a non-answer on that specific language.
All right, let's hear from Judge Bush or Judge Bartlett.
Judge Rogers from.
Okay. Introduce yourself. Turn your green button on, introduce yourself, and tell us what we need to hear.
We are spoiled in our courtrooms, Mr. Chair, because our microphones are always on, so. Good morning. My name is Catherine Rogers, and I am a district court judge in Cheyenne, in the 1st Judicial District, and I'm here to speak on behalf of our branch regarding the need. And perhaps I don't need to sell you all on the need this morning for some attention to be paid to judicial security, but I think that it's important for you all to understand that threats against the judiciary are on the rise nationwide, and they're in the hundreds of percentages. It's becoming a more and more significant issue, and we're seeing it here at home. I will tell you all that this spring, this April, Judge Julie Kasurik from Texas, from Austin, came to speak to the district court judges here in Casper when we were meeting. And Judge Kasurik is an individual who went to a football game one fall night with her son and drove home and was ambushed with an assassination attack in her driveway. And it's very interesting to see her in person. The entire left side of her body is completely pockmarked. And it's from the glass shatter that entered her skin all down the left side of her body, from her assailant, who was a criminal defendant who was appearing before her and had appeared before her in the past. She lost her pinky finger on her left side, or on her left hand. She was out of work for 3 months and she went back and continued to serve. And now she speaks nationwide to the issue of judicial security. Most people, I think, know about the story of Judge Esther Salas, who is a federal judge in New Jersey, whose young adult son one summer night opened the front door when the doorbell rang and was gunned down and is now deceased. Judge Salas's husband was right behind their son, and he was critically injured. That individual was an attorney who was disgruntled and had carried out a vendetta for years, was stalking her, was staking her out, and her family knew where her son went to school, knew where their family went to church. Bringing things a bit closer to home, I will tell you that we have, and I won't read every story, but things like that happen here too in Wyoming. One of my colleagues started to be harassed in writing initially at work, but then at home. This litigant, this disgruntled civil litigant who has a history of mental illness, found my colleague's home address and started writing to him at home. And my colleague became so concerned that he started installing home security equipment at his home. And one weekend day, my colleague walked out of his front door in process of installing home security equipment to face this individual on his front porch. And my colleague's young child was standing right behind him. It was a terrifying event for him. And my colleague then called law enforcement, who responded very quickly. And in the investigation, they learned that this individual, when they caught up with this individual had left my colleague's home, but was headed back there. I have female colleagues from other parts of the state who have been threatened with sexual assault, approached in their parking lots at work, approached in the community. I'm not sure what to say to stress, that could stress enough the concerns that we as judges have in doing the work that we do. While it is not our job to make people mad, our job is to administer justice, of course. The work that we do makes very dangerous people mad. And I just wanted to be here today to speak on behalf of myself and my colleagues regarding this very important issue. Thank you for your attention. I will tell you that just last night when I was packing up to come up here to Casper, I have a 12-year-old son. Doorbell rang. Every time the doorbell rings, that kid goes straight to the door. He's curious, he's 12. And every time the doorbell rings, I'm terrified. And I don't know what to tell him. Do I tell him that judges' sons get shot at the front door? Do I tell him, don't answer the door, it's dangerous, be afraid? We as judges and parents of children have a number of challenges just to balance these security issues and our desire and commitment to doing our jobs and performing our functions. And so I'll turn it over to Judge Bartlett. Thank you, Mr. Chair, for this time. And thank you again to the committee for your attention to this very important issue.
Thank you. Judge Bartlett.
Thank you, Chairman and members of the committee. My name's Wendy Bartlett. I'm a circuit court judge in the 6th Judicial District, which is in Campbell County, Crook and Weston. I've been on the bench since about 2010. Thank you for the opportunity to speak with all of you today. I wanted to share my most recent experience with respect to judicial safety. On August 2nd, 2023, at about 10:30 in the evening, my phone rang. I recognized the caller ID as a local police officer, and I figured he was just calling for a search warrant. I was wrong. A Gillette police officer advised me that an inmate in the jail had just reported to detention officers that he had arranged for a person to plant a bomb at my house that day. I recognized the individual's name as I was the assigned judge on his 6 pending cases. I was aware that he might not be mentally stable, but still. After learning that the officers were already outside of my home, I invited them in, and my husband and I met with them to discuss options. Unfortunately, our security system did not have cameras, and our video doorbell had limited functions. Officers offered to walk through the property, but my husband and I were in a better position to recognize anything out of place. The closest bomb canine was in Cheyenne, and that seemed like an unreasonable request. We ended up thanking the officers and sending them away. We grabbed a flashlight and did our own search and went to bed. Then we laid there. But if there was a chance? Likely there wasn't, but still. We made it through the night, and the next day we bought security cameras. As of today, no charges have been filed against this individual. My experience is just one of many that the judges around Wyoming have dealt with frequently. And I may have I did sign on for this job, and maybe that situation, but my husband and my family certainly didn't. It's time to protect our public officials. Thank you.
Thank you. Questions for either of the judges? Representative Jennings.
Thank you, Mr. Chairman. Judge, I appreciate this is a difficult thing for you and difficult for everyone to grapple, because judges aren't the only ones that get that. But you said something that always catches my attention. This person committed a crime in threatening you, and then you said, and everybody, most everybody here is in law enforcement or some way, or judiciary. Then you said, as of yet, there's no charges. Why not?
Judge Bartlett.
Mr. Chairman and Representative Jennings, I can't speak to the decision or charging decisions that the county attorney is making. I do know that a report was forwarded to his office, but I don't know why he hasn't yet. And I would just say the statute as it is right now, where it refers to officer, there's potentially some confusion on whether that means officer of the court or public officer or peace officer. So that's about the best answer I can give you.
Okay. Thank you. Further question? Just a quick question for you all. If any one of you want to jump in here, in terms of the staff comment question about including municipal court judges, magistrates, commissioners, court commissioners, any thoughts on whether the statute needs to be broad enough to capture all of those folks? Are we seeing any threats against those types of officials?
Mr. Chair, before I was appointed in 2009 to serve as a circuit court judge, I served as a circuit court magistrate. So I was in private practice and filling in at the Laramie County Circuit Court. I was threatened then as a magistrate. A threatening letter was transmitted regarding a civil case that I presided over. And so my personal experience is that anybody who does this work, regardless of the title you bestow, is subject to threats and likely has received some sort of threat.
Representative Jennings.
Follow up, Mr. Chairman. So had that threat happened to one of your judges in courtroom, it would have been contempt of court, and you personally would have responded correctly? Is that correct? So this person is inside being held, and there is no way that the court can go back and reach into that and say, this is contempt of court. He may not have said it directly in the courtroom, but if you could just help me understand that a little more, because it sure sounds like contempt of court.
Judge Bartlett.
Mr. Chairman and Representative Jennings, well, first thing I did the next morning is reassign my cases with him because I had a conflict of interest. It would be inappropriate for me to hold him in contempt, I think, when he's threatening my life. Maybe another judge could do that. Even so, the remedies for contempt, I can sentence them to jail, or that's about it, really. So I don't know that that would have accomplished anything that wasn't already happening. He was in jail.
And Judge Bartlett, you didn't have any firsthand knowledge. All the information you had about this threat came to you through law enforcement. So it's not like something happens in the courtroom in front of you where you have personal understanding that they're contempt. And here you're receiving a report.
Right,
Correct.
and it could potentially be what we would call indirect contempt of court work, but generally we use that for people who don't pay their fines or don't do their counseling when they're outside the court. So, I mean, I had seen the gentleman in court previously and we got along just fine, so.
Justice Finn, I see your green light.
Mr. Chairman, yeah, I'd like to respond to that briefly there. Representative Jennings, there really are two types of contempt of court in it. The first one is direct contempt, and that's somebody that does something in the courtroom directly in front of the judge that's inappropriate. The judge can immediately take action through contempt of court. That happens rarely, but occasionally, and judges have to be guarded not to overuse that contempt, but that's available. The other type is indirect contempt of court, something that happens outside of the courtroom, outside of the presence of the judge, and that is a violation of a court order that somebody hasn't complied with a court order. That's brought to the attention of the judge, and the judge may then, after affording due process, hold somebody in indirect contempt of court. That often happens when you don't pay a fine, in child support, you don't deliver a child, but typically it requires another third party to bring that to and prosecute that to the court. So a threat to a judge outside the courtroom doesn't really quite fit direct or indirect contempt, because they're not violating a court order. They're breaking the law, and they would be breaking this new law in very explicit terms. So that's why contempt doesn't really fit oftentimes in these circumstances.
Representative Jennings.
One more, Mr. Chairman. So let's shift it a little bit. Let's say, okay, the judge can't do much with this. So let's shift it back then to law enforcement. You said they're breaking a law. It's written down, it's statute. They're already breaking a law. And it sounds like somebody's not prosecuting it. I mean, it sounds like there's a breakdown. So we're going to have another piece of paper that's going to then be violated and no one's going to prosecute it either?
Mr. Chairman, Representative Jennings, yes, I think we're going to have another law that explicitly allows that. In my experience, and almost 20 years in the judiciary, I can't think of a case where the current statute has been used in this area. Furthermore, I don't think it's appropriate for us to comment on this particular case because it's in the process right now. I don't know exactly what the county attorney is going to do or not, but I certainly believe that if this legislation was in place, it's a very pointed, very direct to this concern, rather than saying, well, are they an officer of the court? Was it in the court? Arguably they could prosecute it currently, and I think there are considerations with respect to that. But this bill would very explicitly address these concerns. So as with many crimes, you have overlay, you could charge them in different ways. I hope that answers your question, Representative Jennings.
Senator Cooper.
Thank you, Mr. Chairman. Justice Finn, as I look at this, I'm not sure this goes far enough. We've got a problem that's being addressed, and I'm not sure that the type of people that are putting these threats out there are going to be deterred by what I see in this bill. Can you give us some suggestions how we can make this thing reach further and actually give you some really solid protections?
Justice Finn.
Mr. Chairman, Senator Cooper, the first suggestion I would be to help get security for all our judges. We don't have that right now. I mean, home security for all our judges. And we've really been kind of careful to draw a line between the courthouse and outside the courthouse. And the courthouses, for the most part, and we'll be talking about that a little bit later, they're reasonably well protected. It's outside the courthouse that is a concern. And so far, we haven't had a lot of support to get any kind of funding for a home security. The judges have to do that on their own. We've worked up some numbers. The numbers are dropping all the time with respect to that because these systems are getting cheaper and cheaper. The other side of the coin of that is because the systems are getting cheaper and cheaper, judges are doing it more and more on their own. As with anything, how much does a law prevent the crime? We still have murders, we still have sexual assaults, we still have these things. That doesn't mean that we give up. So I think this is a good step in the right direction. I can tell you that in my experience, we're not seeing prosecutions for threats to judges when they show up at the home and outside the courtroom under the current statutory scheme. And I think that I've reached out to county attorneys and I don't have a really clear answer other than they view the current statute as sort of more threatening jurors in a case that's currently being prosecuted, not this broader one. If the legislature sees fit to broaden this and make the punishments harsher, I don't have any objection to that. I think the punishments are, your question addresses a tougher, broader question of even if we have crimes that are identified, that doesn't mean it prohibits those crimes from happening. So I don't have a better answer for you on that. Maybe my colleagues do.
Representative Craigo.
Thank you, Mr. Chairman. So a little bit of a follow-up to the path that Representative Jennings was going down, and that is, so if we take the current statute and let's assume that officer does not include judge, because if I'm a defense lawyer, I think we could make that argument fairly easily. So if it does not include judge, if we were taking a circumstance where someone did threaten a judge, what, says they're going to, let's just say in the abstract, put a bomb at their house, what statute can they be prosecuted under currently?
I wish we had some, Chairman Washit, Representative Craigo, I'm not a prosecutor, and they're probably more familiar with these than I am, frankly, but, there are assault crimes and things of that nature that might fit as well. But other than the assault charges, there's not a lot other than this statute about jurors. And I know we have a prosecutor on the committee, so maybe she can answer that better than I can.
All right, Representative Oakley, you want to chime in?
Yes, thank you, Chairman Washit. And I honestly, I think we're getting a little far afield because I think this is actually, we've been certainly hitting it, and I appreciate Representative Jennings' questions, and specifically what that's hitting is that there's a hole in the statutes. Judges can't just use contempt to prosecute their own people, like somebody, a criminal that's attacking them, that would be wholly inappropriate, and it's just not a legally available option. So what we're discussing here is, and I think we're relatively in agreement, we can kind of, I think, we'll see, but move on from that and just look at the statute and what conduct are we trying to hit here. So it is right, so it's tight and specific for what we're trying to get. I would throw out there, I know this probably isn't the right time, but taking out like influence and intimidating, adding harass, adding some other actions, including the attorneys in here. So we're getting that conduct which we're discussing, which is specifically harassing, intimidating, threatening judges, and attorneys that are part of the legal system. And that's, I think, what we're trying to do here. One of the problems when I say we're getting a little far afield is, of course, it already is illegal to shoot somebody. It's already illegal to do an aggravated assault and battery. So I understand that can happen, but clearly that can be prosecuted. We're talking about something narrower, which can get difficult. That's why I think the wording is important, because threats, you know, there's freedom of speech, things like that. You have to get, so we have to look at what conduct we're going to prohibit here. And I think generally, I'm guessing that we can move forward from there, but contempt won't get you there. And what we're hearing from testimony is that this statute about intimidating and impeding witnesses isn't quite right. So I think there is a hole here. I think we can address it. I think we just need to kind of look at specifically what are the words, what verbs do we want to use to prohibit, what conduct do we want to prohibit? That's my take on this.
Thank you. Well said. Do you have any other witnesses in the room who wish to testify on this topic? Representative Harrelson?
Thank you, Mr. Chairman. So I'll just throw this out to all three of the justices. Thank you guys for coming today. I think every one of us on this line, at least I can say, we've all gotten threats. I mean, you bring a bill and people are grumpy. You voted the way they don't want you to, people are grumpy. We get it. So it's obviously a very real deal. One thing that is there a precedence that have we set a precedence in the past to include the family in on anything else like this? And the only reason I'm saying this is we're watching on a national level right now a family member that has done some very foolish things. And I don't want it to be is I don't want to produce a shield to protect a problem. Does that make sense? And so I don't want it to be a situation where we say, oh, well, you can't say fill in the blank about a justice's son, even though they're doing something that they shouldn't be doing, but we're protecting them under the law. Am I making sense in that statement?
Justice Finn?
Mr. Chairman, Representative Harrelson, you know, you raised something I didn't really think about. I suspect if my son was in high school, got in a bar or a fight in the hallway of the high school, that this wouldn't be pursued. And I think that arguably it could under this language. I would hope that our system and our county attorneys in exercising their discretion could sort that out. On the flip side, I had an instance where I took a picture of an individual that was threatening me to the high school and gave it to the Sheridan High School. Kind of has an entryway, and I, basically they posted that picture for this individual because he was a threat. And I was concerned about the safety of my high school students, my children who are in high school. And certainly if that individual had showed up and threatened them, I would expect that this law be used. So I think you can probably hypothetically think of a lot of circumstances where it doesn't fit. And I think the discretion of the county attorney's office is probably the source to sort that out.
Okay, we're at 15 minutes after 10, so follow up.
Thank you very much, Mr. Chairman. And I definitely hear what you're saying, but at the same time, we're sitting here with a bomb threat and a county attorney that isn't, I mean, maybe I'm wrong, but if one of us on this line made a bomb threat, we probably would have some legal action taken against us. And so I think I understand that we are in the weeds. I understand that, but I'm also saying there's so many facets we got to be careful of. And I just don't want it to be a situation where we create an unwarranted or undue consequence by an action. Do we need to address this? I absolutely believe we do. I just think how, I guess, is the question.
Okay. So we've got these two bill drafts before us. Is there anyone else in the room wishing to testify? Thank you all for your testimony this morning. Anyone else in the room wishing to testify relative to either of these two bill drafts?
This is Tucker Ruby. I'm online. Can you hear me?
I can. Let's bring him in, please. Please continue.
Okay. So my name is Tucker Ruby. Thank you for letting me appear remotely. I was not able to be there in person. I'm the president of the County Attorneys Association. I spoke with Justice Finn about these bills, and kind of gave some input from what the county attorneys thought. As I listened to Judge Bartlett's story and some other things that were presented, I think there's some things that I think Representative Oakley maybe hit on it. There's some wording that I think might be helpful to this. I think there's been some concern from all about, well, why isn't this being prosecuted? I can't speak to that. I do know that the county attorney in Campbell County is pretty busy, and I'm sure that it's something that he's looking into. There may be some issues, and I may have not heard Judge Bartlett correctly, but I think, and if I'm wrong, she can definitely correct me, but I think she said that it had been communicated to a third party about him wanting to place a bomb potentially. And then that came from the jailers, probably from monitoring phone calls, et cetera, that goes on at the jail. And that really kind of points out an issue that we have with this bill. Oftentimes, scenarios that affect judges, affect prosecutors, defense attorneys, witnesses, jurors, et cetera, they don't come from the individual. They come from a third party. And so oftentimes there's something communicated to a third party, and then through that kind of line of communication, a threat comes in. It's not usually a direct threat. And as I read the statute as it currently sits and as the different drafts that are there, I think that's something that could be looked into and could be added. I think the County Attorney Association very much supports everyone they're involved in the court system being protected. And that includes judges, absolutely. We feel like they should be protected, and these protections should be extended to them. But I think there's some wording issues. And so Representative Oakley pointed out potentially harassment. Maybe we need to add stalking, place under surveillance, third-party contact. It's not uncommon that a third party will make an offhand comment to someone to try to influence them that may not necessarily be a threat, but it is definitely meant to try to influence someone that's involved in the judicial system, whether that is a judge, whether that's a prosecutor, defense attorney, or a witness. And so I think from the prosecution standpoint, the wording is somewhat difficult when you have, through a threat, they attempt to impede or intimidate and those sorts of things. It's pretty narrowly tailored and sometimes hard to do something with that. And so I think some expansion of that, I'm not asking for a wholesale expansion, but the thing that we see most often, and this is something that we experience as well, is oftentimes the report or the threat or I don't even want to use threat. Sometimes there's an advisement made by a third party that we shouldn't do something or should do something. And it is directly sent in to try to intimidate or influence someone involved in the process. And that I don't think is addressed and should be addressed. And so that would be my 2 cents as far as those things. More than willing to answer any questions that you may have.
Okay, questions? Seeing none? Thank you very much for your testimony. Anyone else in the room wish to testify? Anybody else on Zoom? No? All right. You want to take one last bite at the apple, Justice Finn?
I'm going, so I'll just
Very
stay
good.
here if that's okay.
So with that, I'll close public comment on 62 and 63. Bring those two to the committee for your preference. Mr. Co-Chairman.
Mr. Chairman, really want to thank our justices for being here, our judges, and appreciate the insights provided by members of the committee. My gut tells me that perhaps we could pursue, where Representative Oakley was going with the more general bill. But I still feel pretty strongly we've got to have 2 bills. Feels like we can do the catch-all, but then specifically in statute address the judges. But that's a layperson who doesn't spend a lot of time in the courtrooms, and So that's kind of where I was leaning. I'd be interested in what other committee members feel about that.
Others? Representative Oakley?
Thank you, Mr. Chairman. I am personally, we're talking about a budget session. We've taken several big bites this interim already. My preference is just to move and work 62.
Is that 62?
Yes, the standalone.
Standalone. Representative Craigle?
Thank you, Mr. Chairman. So I agree with Representative Oakley. I don't know what that process looks like, whether we do that here today or we try to work on some language between now and our next meeting, because I think it's going to be fairly extensive, and we have a very packed schedule today. Maybe we just, I mean, if the committee agrees, we could continue on with the one bill. I think I'm fine with doing that as well, but taking into consideration all the comments that were made, we could work on some language for our final meeting.
Okay, let's come back to that as a motion after we hear some more comments. Representative Chestick?
Thank you, Mr. Chairman. And I'm still not sure which way I would go with this. I do take Chairman Landon's point, though, that I think the two bills do address different things, and therefore it might be worthwhile to have two bills. I see the first bill as addressing it's witness tampering. It's specific to a particular case, which is a crime all by itself, or should be a crime all by itself. And the second bill is a broader one. So maybe the second one is included the witness intimidation or something connected to an individual case might be covered by the second bill. But so I'm not sure, I'm not certain whether I would need two bills or not, but I do see the point, and I think we at least should consider the fact that there are two separate kinds of conduct that are at risk here, that should be punished here, and I'm very interested in seeing what we can do with both bills.
Any other comment? Mr. Co-Chairman.
So, Mr. Chairman, I appreciate those comments, and I think there's wisdom in a couple of our representatives have indicated and alluded to the fact that we have a lot of work to do, and it is a budget session. I think maybe moving one bill, maybe that's what we can do for this interim, and then maybe we continue to work on all the other things. So appreciate that. Thanks for your input.
So do we have a motion relative to 60? Oh, Representative Oakley.
No, I'm getting ahead of you. Yes, I do.
Go ahead with your motion.
I'd like to move 24 LSO 62.
For further consideration at the November meeting, is that your motion?
I guess I'd take direction. I do have a few ideas for word changes, whether we want to do that right now or not. That's up to you, Mr. Chairman.
Yeah, I think my preference would be that we formalize some proposed amendments before the November meeting. Just take a vote today whether we want to move, deal with draft 62 at our November meeting and make that a motion, and people can bring amendments as needed for the November meeting. That's your motion?
Sure.
So we have a motion to.
I already moved it. So.
Second by Representative Nemec. Further discussion on the motion that we take up 62 at our November meeting and members who come prepared with amendments. Seeing no discussion, all in favor of carrying 62 to the November meeting, say aye.
Aye.
Those opposed, no. One opposed, so we'll take 62 up in November. Is there a motion relative to 63? Hearing none. Okay. Thank you very much. Mr. Co-Chairman.
Mr. Co-Chairman, thank you. I just wanted to remind members of the committee that as we work through today and on through the third meeting, there may be bills that someone would have an interest in keeping alive, and certainly any one of us can bring a bill forward. So please remember that. Just because the committee isn't necessarily sponsoring one, that doesn't mean you won't see it in the session. So.
Okay, Mr. Fuller, I think that takes us to 64.
So, Mr. Chairman, 24 LSO 64.4, this is 3-03 in the meeting materials. This is a draft after discussion that a member asked for based on Arizona law, and it would establish the criminal offense of unlawful publication of personal information of judges. So this would be in a new article in statute. On page 2, there are a couple of definitions. So immediate family on page 2, line 4, and a similar question for the committee on this definition in this bill as in the previous bills, what the scope of that should be. And then the same for judge. Currently includes Supreme Court Justice, District Judge, Circuit Judge, and Chancery Judge. Page 2, line 25 defines personal information. This is based on current Arizona law, and it means a home address, telephone number, cell phone number, pager number, photograph directions to a home, photograph of the home, and a photograph of any vehicle of a judge. Then on page 3, line 2, so with the exceptions that I'll get to in a moment, no person shall knowingly make available on the internet the personal information of a judge or the judge's immediate family if first, the dissemination or publication of the personal information poses an imminent and serious threat to the judge's or the immediate family safety, and 2, the threat is reasonably apparent to the person making the information available on the internet to be serious and imminent. Page 3, line 15 is an exception to that prohibition. It is not a violation for the county clerk, county assessor, or county treasurer to publish personal information of a judge or immediate family on the internet if done so in good faith and in the ordinary course of carrying out the applicable officer's duties. And then page 4, Mr. Chairman, is the penalty for a violation. This penalty is based on the penalty in Arizona law for a first-time offender. So it'd be imprisonment up to 2 years, a fine up to $5,000 or both. And the staff comment on page 4 just notes where that penalty came from. And then, Mr. Chairman, members of the committee, you have information on this bill as well that was provided separately. A question of the First Amendment. And the two things I would note here are, Mr. Chairman, the bill prescribes publication only on the internet, and it prescribes publication of information that, as contemplated in the bill, as contemplated in Arizona law, may already be published under another source. So, Mr. Chairman, you have information about that. With that, I'd stand for questions.
Questions for Mr. Fuller? Representative Chestik.
Thank you, Mr. Chairman. Mr. Fuller, on the staff comment on page 2, you have a question about whether federal judges stationed in Wyoming should be included. Is there an equivalent federal statute that would make it a federal crime to do these things?
Mr. Chairman, Representative Chestik, there is now, and I believe it was Judge Rogers who mentioned the federal judge and the incident occurring to her son. In response to that incident, Congress passed a law, not identical to this, but providing those judges the ability basically to opt out and require an opt-out of publication of their information.
Further questions? Senator Schuler.
Thank you, Mr. Chairman. Page 3, Mr. Fuller, section C. I looked at that a couple different times and wondered what the exceptions would be for the county clerks. The only thing I could come up with is if maybe they haven't paid their property taxes, then they might have the ability to put the judge's name and information out there. But would there be any other reason for that, or is that? Could you explain that?
Mr. Fuller.
Mr. Chairman, Senator Schuler, I don't know if every county in Wyoming does this, but I know a number of counties have a property search through the county assessor's website where pretty much I think any property information is available for online search.
Mr. Co-Chairman.
Thank you, Mr. Chairman. So, Mr. Fuller, as you drafted this bill, did you give consideration to us being narrow in terms of only criminalizing publishing on the internet versus all the other mediums that are available to someone if they wanted to do that to a particular judge? Is the Arizona law that restricted?
Mr. Fuller.
Mr. Chairman, Chairman Landon, it is, I believe, limited to the internet. That law has, as far as I'm aware, has not been challenged, or at least has not come up in a reported decision concerning that law. It was raised in a separate civil action where a person was charged with that offense and was challenging that as a malicious prosecution. But Mr. Chairman, I believe the Arizona law is also just the internet.
Follow up.
So, Mr. Chairman, thank you. So, Mr. Fuller, that I appreciated your memo, by the way, very informative, and you did point to that. I just wanted to make sure that we understood that we're being very specific here. Someone could potentially then, Mr. Fuller, send out a mailing with a letter and include anything they wanted to include in a letter, correct?
Yep, Mr. Chairman, Chairman Landon, under this bill, that would be correct. Doing that or taking any other action, any other medium of publication would not be prescribed under this bill draft. There may well be other statutes depending on the course of conduct that may be implicated, but this one I don't think would be.
Okay, further questions, Mr. Fuller? Seeing none. Justice Finn, you're at the table. Would you like to comment on 64?
Mr. Chairman, very briefly, all I want to say is thank you for this effort. This bill's a tougher bill and that addresses some of the concerns I expressed earlier, but also, you know, we live in Wyoming, and with or without this bill, everybody knows what I drive and where I live pretty quickly. So I certainly support this effort. I don't have a lot further comment on that other than when you hear from other folks from the Supreme Court, we have a line item budget, a very modest amount. There are people that we can contract for that go out and scrub the internet of this data for us, and they're experts in that area. And I think the request is somewhere between $25,000 and $50,000 to contract with somebody to go out and do that for the judiciary. And I certainly hope that you would support that. And frankly, I would, if I had to pick between one of the two, I would want that those funds to do that scrubbing on the internet versus this bill. But I'm certainly not here to talk against the bill, and I appreciate the effort.
So that funding to scrub the internet, that's part of the budget bill that we'll see in.
Yeah, I think you'll be hearing from other folks from the court later today on the, it's a very modest, very almost nominal request in some of the things that I'll be talking about.
Any questions, Justice Finn? Representative Craigle?
Thank you, Mr. Chairman. Justice Fenn, so would it be possible to cover this activity, generally speaking, in the bill draft we just approved moving forward? I mean, is there a way we could put a definition, for example, include it within the definition of harassment? For example, if we ended up putting that word within the previous bill draft, could we actually kill two birds at one time?
Mr. Chairman, Representative Craigle, yes, you know, of the bills that are proposed, I think this is the one that I put lowest priority. So the other bill, intimidating judges, you know, that really addresses the bigger concern we have. But all the Supreme Court justices received letters from an individual about a case, and it was clear that it came through the assessor because it was sent to my home in Sheridan, was also sent to my condominium that I bought in Cheyenne, was actually sent to this garage that I bought in Cheyenne. It's in the assessor. So they're getting access to that, but that's not the the bigger concern is more the threats. So
Representative Oakley.
Thank you, Mr. Chairman and Justice Finn. In fact, this bill requires that one of the elements would be to prove that it poses an imminent and serious threat. Thereby, if we pass the other one, it is encompassed within that. It would be encompassed under that prohibited conduct. Would you agree?
Mr. Chairman, I agree with Representative Oakley.
Further questions? Seeing none. Anyone online wishing to testify about Bill Draft 64? No one? Anybody else in the room wanting to talk about Bill Draft 64? Seeing none, thank you, Justice Finn. Committee, your preference on 64? Representative Chestic.
I'm not sure if I need to make a motion or a suggestion. I like Representative Crago's suggestion that we could maybe wrap this into the prior bill. And if I could make that a suggestion to LSO to try and combine the two. I think if we can move one bill rather than two, and cover both things, I think that's probably the best way to go here, personally.
Okay. I think proposed amendments for that other bill are wide open for the next meeting. Otherwise, seeing nothing further on 64, we're going to be done with that. Let's take about 10 minutes, committee. Take a quick break. Been at it all morning, and take about 10 minutes and come back and the rest of the All right, Mr. Fuller, number 65.
Yep, so, Mr. Chairman, 24 LSO 65, 0.4, so it's 3-04 in the meeting materials. This is a draft the committee requested in April, and the committee's direction was to include a couple of different options for language, and so I'll go through that in the bill. Simply, this bill would make clear that the county sheriff is responsible for providing security for courts and judges in the sheriff's county. So on page 2, line 5, this would be an amendment to 18.3.604. And this new language would require the sheriff or the sheriff's deputy to provide security for all courts of record in the county. And then security must include, page 2, line 10, the presence of a sheriff or a deputy in each courtroom where a court is in session, escorts within the courtroom, outside the courtroom, or outside the courthouse when requested by a judge, and then any other reasonable security measure requested by a judge of a court of record in the sheriff's county. And then the staff comment is an alternate version of this language that's a bit broader. And so it would just be, I'm on page 3, a sentence in 18.3.604 that would require the provision of security for any specified court proceeding in the sheriff's county upon request by a judge. And then the last sentence of the staff comment is just a question of whether any funding may be necessary to implement this act. With that, Mr. Chairman, I stand for questions.
Questions for Mr. Fuller? Saying none. Justice Finn, you're still at your seat. Let's hear from you first.
Mr. Chairman, I am Justice John Finn and also Chair of the Court Security Commission. I don't have a lot to say on this other than thank you for the bill. It addresses the concern that I raised when I last was before you, but I will tell you that also highlights the broader concern that we have in the state and the disparity we have throughout the state with different counties and their resources. There just simply isn't enough manpower to achieve this right now, and I think we really need to reach out and help our sheriffs in addressing that issue. You're going to be hearing from them and some of their concerns. I don't disagree with their concerns. At the same time, it seems like it's a fairly simple request to expect to have a deputy present during a court hearing, and that's something that you'll hear from them that they can't do right now for lack of manpower. And it's a real challenge and something that highlights it. Likewise, with respect to, my focus on the Security Commission has been manpower and training, and this kind of highlights that issue. And we see great disparity between the counties. So while I very much appreciate the effort on the bill and certainly will speak in favor of it, I also recognize the practicality, and I think it's important to hear from the other folks, particularly the Sheriff's Office, that are here today, and I know they're anxious to talk to you about it. I do have Judge Bush with me as well, who is from Crook County, a circuit court judge in Crook County and Weston County, and she has some brief comments. So if there are any questions, I'd be happy to answer them. Otherwise, I'll let the other folks address these issues.
Thank you, Mr. Chairman, and Justice Finn, perhaps this is what we're going to get to, but you just said, addressing manpower. But my question is, how does this bill do that? Because the reality is, if the sheriffs in our counties are already understaffed and then we're expanding their duties and dictating to them. So I don't see how this bill addresses that. First of all, and I guess then if so, is the court or the state willing to, look at funding some of this, which I know, again, we talked about the fiscal note, but is the court willing to, be a part of helping the sheriff solve this?
Justice Finn.
Mr. Chairman, Representative Oakley, I agree with everything you said. I don't think the sheriffs can comply with this, and if they had to comply with it, because it's a state statute required shall, they would be pulling people off the street or out of detention, and it's a real challenge for them. The broader issue is we're absolutely here to support the sheriffs in addressing some of the shortfall. How we do that, I'm not sure, but I would point out that the sheriffs are protecting a state entity, a state court within a county building with county resources. And they're spread thin. And how we help them ultimately is probably through some kind of appropriation earmarked for that. But even if you talk to the sheriffs, they'll tell you that this is a bigger challenge than that. It's not just simply throwing money at it, because even with money, they can't fill their positions they have right now. So it's something that's going on, countrywide in these vacancies in this area and many other areas, but it sure highlights the issue. Again, my point is you would think it would be a fairly simple request to expect to have a deputy present during a court hearing, regardless of what kind of hearing that is. And the practicality is that isn't happening in many counties, and it can't happen right now in many counties. So I recognize this. If you were to actually enact this bill, we're robbing Peter to pay Paul. But it does highlight the broader, bigger issue of security within our courts. We have plenty of room to improve. And I say that very grateful of what the sheriffs are doing. And we're here lockstep with them with respect to that.
Judge Bush.
Good morning, Mr. Chairman, members of the committee. My name is Linda Bush, and I am the Circuit Court Judge for Crook and Weston counties. I also have the privilege of assisting with hearings in Campbell County. I am here to talk about the concerns with court security as it stands now, understanding everything that Justice Fenn has pointed out already. Being in courtrooms in 3 different counties has given me the opportunity to experience court security on different levels, from having a court security officer in the courtroom for almost every hearing to having an officer in the courtroom for only hearings when it's requested by the court. With that said, I have never been denied a request for court security, and my clerks and I work well with the sheriff's offices and try to give them sufficient notice so that they can schedule appropriate staff to accommodate the court's request. I will tell you that having security only when requested does pose unique challenges. All cases can be highly emotional for the parties because you have one party accusing another party of doing something wrong. And in many of the cases, I have never had either party in my courtroom, and I know nothing about them. In determining whether I need to request court security, I try to take into account what type of hearing it is, what the allegations are, who will be in the courtroom, will there be any members of the public, are there attorneys involved, whether one party will be appearing by video for that hearing, or will both parties be present in the courtroom. And the only information that I have about a case to decide this is what is contained in the file, which can be very limited information when walking into that first hearing. There have been times that I didn't think I needed court security and then had to call and request it in the middle of a hearing. One story I'd like to share as an example of that. The hearing was on a request to extend a protection order. The petitioner was appearing by video and the respondent was in the courtroom, and the only other people in the courtroom were my clerk and staff from the county attorney's office who were in the gallery, so I chose not to request court security. While administering the oath, the respondent began to make inappropriate comments about the petitioner. I admonished him for the comments and continued on with the hearing. I explained to the parties how the proceeding would be conducted and asked both parties if they understood. The respondent informed me at that time that he had some letters that he wanted me to read. I explained to him that I did not want to read the letters because they were communications from his attorney, but I did ask him if he wished to share why they were relevant to the hearing, but without disclosing the content of the letters. He started walking towards the bench with the papers, and I again explained that I did not want to see them, and he continued to the bench and tossed them at me. As he was walking back to his seat, I asked my clerk to call for court security. I found out after the hearing at the same time, a member of the county attorney's office who was in the gallery also stepped out and had requested court security. As I was waiting for the officer to arrive, I proceeded with the hearing, and the respondent continued to be disruptive and make gestures toward the monitor at the petitioner. I again admonished the respondent for his behavior, but his behavior continued. Without having an officer in the courtroom, my options were very limited on how to address the situation and prevent it from escalating. Once court security arrived, the respondent's behavior continued, and ultimately I held him in contempt, and it took 2 officers to take control of the respondent. As I stated earlier, I've never been denied a request for court security, and I appreciate the sheriff's offices accommodating those requests and understand that sometimes that they can be difficult to do. But it's also very difficult to try to predict whether you will need court security or not. If I opt not to request security and in the middle of the hearing I determine I need it, it is going to take about 5 minutes for an officer to get to the courtroom, if not longer. And who knows what could happen in that 5 minutes. I can't predict the future, and by only having security when requested, that's what I'm being asked to do, and it is an impossible task. Mr. Chairman, members of the committee, thank you for your time and for allowing me to testify today.
Any questions for Judge Bush? I'd just like to say thank you for your testimony. I think getting a firsthand account is always useful to help us try and put ourselves in your shoes and try and think about what the proper policy decision might be.
Thank you.
Thank you. I'm not sure, but I think there's others in the room who want to testify about this. Lucky guess, I guess. Please proceed. Introduce yourself. Begin.
Mr. Chairman, my name is Alan Thompson. I'm the Executive Director of WASCOP, or the Wyoming Association of Sheriffs and Chiefs of Police, and I'm joined by our President and Vice President of the Sheriff's Association that will have a few comments for you. I would just like to mention that we have visited with the sheriffs across most counties across the state, and while the fiscal issues with this bill are paramount, it's actually the workforce issues that are more of a concern for us, because even if the fiscal issues were met, the workforce issues are something we continue to struggle with. And I'd like to turn it over to the sheriffs.
Sheriff.
Good morning, Mr. Chairman. My name is John Harlan. I'm the Natrona County Sheriff and the President of the Wyoming Sheriff's Association. Great conversation here today. Thank you for taking this topic up. We have been involved quite a bit with this conversation across the state and trying to meet these challenges. We stand before you today in opposition to the language in this draft bill. And I'd like to note that specifically it's the language that we're opposing. Your Wyoming sheriffs remain committed to protecting and defending our judges, officers of the court, staff, and the whole judicial process. It's very important. We take it to heart, and I think that's worthy to say. It's specifically the language in the draft bill that we're opposing. So much as Justice Finn alluded to, there are a wide range of diversity between counties in the entire state. So when we look at staffing requirements, fiscal responsibilities, how we recruit, retain qualified deputy sheriffs, the challenges are very complex. And to put one piece of legislation in that's very specific and has specific requirements of the sheriff, I think that's not well represented across the state as a whole.
Fair enough. Any questions for Sheriff Harlan? It's always a pleasure to have Sheriff with us. Thank you for being here today.
Thank you, sir.
Further?
Mr. Chairman, members of the committee, Levi Dominguez, Sheridan County Sheriff, Vice President of the Wyoming Sheriff's Association. I just want to thank you for all of you for your time and consideration with this particular bill. And as you've heard today, the wording in which this bill is drafted, specifically the presence of the sheriff or one or more deputies in each courtroom where a court is in session, will cause significant negative impacts on staffing within sheriff's office and potentially the overall safety within the state. While this significantly impacts sheriff's offices, smaller sheriff's offices, please know the larger sheriff's offices may be impacted as well. I'm fortunate to have a great working relationship with all of Sheridan County's judges who serve the 4th Judicial District. And the Sheridan County Sheriff's Office currently is able to provide one full-time deputy within the Sheridan County Courthouse to provide security for two main courts, circuit and district, throughout the week, but also a third court that comes in once a week, a third district court. And that court deputy is often running between and is in constant communication with the courts on prioritizing which hearings need to be attended by law enforcement throughout that week. And after being made aware of this bill, I set up a meeting with our three Georgia judges and the courthouse deputy, and wanting to know if Sheridan County was particularly missing the mark. And with the judges' permissions, they are allowing me to share some of our conversation we had with you today. And by no means am I testifying that Sheridan County is the model county, but what I heard from our judges is what we're doing in Sheridan County is working in Sheridan County. And so like a number of the comments that have made, and even with Justice Fenn making the comments that, you know, this current draft of this bill will require every sheriff in Wyoming to provide security in every single hearing for every single court within the county. And when I asked our judges if this was necessary, they said absolutely not. It was even mentioned it would maybe a misuse of resources at times. And so the judges did mention they do like having law enforcement presence, a deputy within the building during business hours. And I would agree with that in Sheridan County, that works for Sheridan County. At the end of our meeting, we all agreed that this appears to be maybe an individual county issue where, you know, the county and the courts come together and define what's best for each county. And maybe this bill isn't necessarily, or the wording necessary how it's currently drafted. And I understand that the safety of the courts and everyone in the courts is paramount, but again, this would certainly tie the hands of many sheriffs, providing, you know, having to have law enforcement in every courtroom and in every hearing, and it could very well as easily affect the well-being and the safety of the communities as well, if manpower is short and having to pull statutorily required law enforcement to be in the courts and pull law enforcement from their patrol assignments into the courts during that time. You know, in Sheridan County, we would have to request additional two more deputies to make this work for how it's currently written in this statute. And it would be additional cost to the counties. But the cost, again, is something that's, while it's an additional cost, I'm not sure if we can recruit additional manpower and law enforcement in our profession right now. We're seeing across the state and the region and the country where law enforcement agencies are struggling to fill the current positions we have open at this time. So I would ask you to just consider all the comments and testimony heard today and ask that representatives of the courts and sheriffs to sit down at the table so we can come up with a solution that will work for all counties. And if that's not the direction of this committee choose, then I'd ask that all of you consider the alternate draft that was put forward that is provided, in which states the county sheriff or sheriff's deputy shall provide security for any specified court proceeding in the sheriff's county upon, and here's a request and an addition that I would ask is upon a reasonable request by a judge in the county. And I would ask reasonable be defined in that as well. And I'll end with this, and I appreciate your time, that this bill will have, you know, a financial hardship for every county. And if the state were to consider providing additional funding for adding deputies and law enforcement officers to the courts, I'd argue maybe the state's priorities, you know, we need to look at what's important here. And I'm not saying that court security is not important, just as what the Natrona County Sheriff had mentioned, that we want to provide court security and do the best we can. But historically, it's been proven and shown year in and year out that the greatest propensity for violent crime to occur within public buildings is within our schools and colleges. And if the state's priorities are in check with what we have seen within our country and our own state, then funding for additional law enforcement in public buildings should first be addressed to add more law enforcement in our schools before anything else. And I thank you for your time. Any questions?
Questions? Senator Schuler.
Thank you, Mr. Chairman. Just to go back, I guess this question would be for any one of the three gentlemen up here. Our issues, and I understand that there's staffing issues. I guess I'm wondering why. Is it because no one wants to be a cop or a sheriff anymore? Are we not paying them enough? Do we have incentives built in? I mean, is there some way we could incentivize folks that maybe want to work in the court system? Maybe give them a little bonus pay or some vacation or something extra? I don't know. I just keep thinking that maybe we're not doing enough to, encourage maybe our young people, internships, those kinds of things. What do you see as a solution to this issue?
Mr. Chair. Senator Schuler, great comments. I think there's been quite a bit of work done on this topic. It's not something that's unique to Wyoming. There have been several occurrences, incidents throughout the country in the recent years that have changed the narrative in our country as far as respect of law enforcement and the desire of people that are growing up to have a profession in law enforcement. So those things, along with the division in politics and some of the things going on in our country kind of have shaped that. So it's certainly not unique to us. I can assure you that there are a wealth of creative ideas on how to recruit, hire, and retain a good quality employees in law enforcement. Some of those are very outside the box. Some work, some don't work. We do look at different types of incentives. Different incentives when it comes to pay, stepping grades within the pay, benefits, equipment allowances. There's a wide range of things that everybody has tried, things that work for a particular, in this instance for a county, may not work in another county. We have worked on recruitment efforts from outside of the state of Wyoming to attract people to come and live and enjoy everything that Wyoming has to offer, as well as a career in law enforcement. We have seen some success in that, but it certainly remains a challenge. And much to the conversation piece of the funding for agencies that have open positions, that those positions are already funded. You just can't fill them. So if you increase the funding, then you have more positions that aren't filled. So that's really where the challenge comes. And certainly back to this topic, court security is very, very important, and I think we all realize that, and all of the sheriffs across Wyoming do. And without sounding dramatic, for some counties, this becomes an issue of, if the statute mandates I put someone in court for a civil hearing, do I not send somebody to my school? Do I not send somebody to respond for calls for service, for help? So I certainly don't want to sound dramatic, but when we start reading the statutes and the sheriffs are running their office in their respective counties and they're providing those services to their citizens, those are the kind of conversations that we have with ourselves. Mr. Chairman, thank you.
Further questions? Representative Oakley.
Thank you, Chairman Washut. Quick follow-up. Do you know what the average salary a deputy is making in Wyoming right now?
Mr. Chairman. Representative Oakley, I do not know what the average salary is. I can tell you my office starts right around $58,000 a year.
Mr. Chairman.
Sheridan.
Representative Oakley, and just to follow up with the sheriff's comment in Natrona County, our office starts a deputy out at $54,000 a year, and we're below the average, but I do not know what the average is.
Okay. Just a quick comment. It seems to me that security systems work until they don't, right? Yeah, so it's working in your courthouse, everybody's content with it until it doesn't, right? On the day when it doesn't, then everybody notices that one deputy 5 minutes away did not fulfill the need on that moment, right? And those are the things that bother me about this, is that trying to predict when and which court, which hearings, these cases where, lawyers act violently against the judge, you know, or after hours. You know, you have a deputy in the courthouse from 8 to 5, but I drive by our courthouse and I see judges working, their cars are still in the lot late at night. And so those are my concerns about the whole courthouse security arrangement, is that when you're sharing one deputy for the whole building, not just the court, but also the assessor's office and the treasurer's office, whoever might have a problem, you've got one deputy in the building to handle those things. It works until things go sideways. And then you've got a deputy who might be on the other end of the building several minutes away.
Mr. Chairman, if I may respond. Certainly very valuable comment. I guess my thought would be our citizens have the same concerns. Law enforcement just can't be everywhere all the time. We do our absolute best with what we have, with what the citizens will allow us to use, being fiscally responsible and trying creatively to do everything we can within our means. Schools are the same way. Schools are a challenge. In our county, that's 5,300 square miles, we're spread out. So have deputies in all those areas all the time is tough. There's certainly a lot of challenges to law enforcement in general. And I think it goes back to the comment that that a lot of these solutions probably lie at the county level with relationships and partnerships between the sheriff, the courts, and the county commissioners, and work on funding and staffing and addressing problems as they come up. I think on the sheriff's side of that, there's certainly a lot of commitment to that goal, to reaching those goals within what the citizens and the parameters that we have to accomplish those goals.
All right, anyone else in the room wishing to testify? You want one more bite at the apple? All right, Ms. Thompson.
Mr. Chairman, thank you. I also want to recognize that we have representative sheriffs from our largest populated county and our smallest populated county, and a few in between in the room also, should you have any further questions about specific areas of the state. Thank you.
Thank you. Anyone else in the room wishing to testify? Anyone on Zoom? Committee, does anyone have questions for any of the sheriffs from around the counties and state that came? Okay. I'll close public comment. Bring it before the committee. Committee, what's your pleasure on 65? I see no motion, so I think that bill's going to, Mr. Co-Chairman.
Mr. Co-Chairman, just a quick comment. Really appreciated the sheriffs being here. Justice Finn, I agree with no motion on the bill. I just think it was a very important topic for us to take up. We may want to consider, Mr. Chairman, in a memo that we may send forward to our friends on the Appropriations Committee, for example, we may want to at least give a heads up on this front that that this has come to our attention. There's not an easy fix, but moving forward, it's something that may come to us again. And it has budget implications.
Certainly does. Thank you. Any other comments before we move on? All right. For folks in the room, we do have a hard break at 11:30. The committee has a tour, the very related tour on the Townsend Justice Center downtown. We're going to take a look at the courthouse security arrangement here in Natrona County. And so we have a hard break at 11:30 and we're at 11:15. So I would like to go ahead and move on. The judicial branch topics, Administrative Office of the Court. Madam Chief Justice, Ms. Butler. perhaps we can at least introduce the conversation before we break for lunch.
Mr. Chairman, thank you. I'm Kate Fox, Chief Justice of the Wyoming Supreme Court. I think it'll work fine. I can do an introduction, and then I'm going to hand over the heavy lifting to Elisa Butler, and perhaps that will happen after lunch. We'll see how it goes. Thank you, committee members, for your time and attention. This is an informational matter. It's a big deal because it's a big ask for the judicial branch. I just want to back up and say our mission in the Wyoming Judicial Branch has always been to provide open access to the courts for the people of Wyoming pursuant to Article 1, Section 8. And we've done that since statehood. But in the last couple of decades, that mission has really changed quite a bit along with the changes in our society, so that instead of judges just calling balls and strikes with parties who appear in court represented by attorneys, we have a very different landscape now with self-represented litigants. We have many more mentally ill people, not just in the criminal justice system, but really in all aspects of life, especially juvenile law. As you know, we have big projects with electronic case management and e-filing, which is now rolled out, I believe, in 6 of our district courts. Lots of different work to be done. We provide court interpreter services, which are more and more in demand and are required as well by the Constitution. And as with any organization that I think most of you are familiar with, there are more and more federal and state legal requirements as employers. We're a small branch. Only 330 or so people work in the Wyoming Judicial Branch, but that's still an organization that requires a great deal of processing and compliance with the law. So today's judicial branch really must provide far more complex services to the people of Wyoming in order to perform our mission. And we've realized that that demands more resources than we have asked for in the past. We have prided ourselves on austerity, and I respect this committee and the legislature's concern about fiscal responsibility, but there comes a time that we need more resources to really do right by the citizens of Wyoming. We've spent the last couple years, and I won't take a lot of your time talking about some of the projects in the judicial branch. We've worked with the National Center for State Courts to really look at how our branch functions and see how we can do it better for our judges and for the citizens. And we're doing some exciting projects, which you'll hear more about. But one of the things that the National Center for State Courts advised us is that we have the lowest administrative staff of any state in the nation, even accounting for the fact that we have the lowest population as well. So that's the reason that we are going to be asking for 10 new positions for the administrative staff, in addition to 9 more circuit court clerks. I don't know, we're not talking about the clerks today, right? So just to give you a little preview of the sticker shock, today our discussion is going to be about the 10 administrative positions that we'll be asking for. So with that, I think I'll turn it over to Elisa Butler, our court administrator, unless, do you have questions of me, Mr. Chairman?
Madam Chief Justice, I believe last year we added 2 staff attorney positions, and as I read through the lengthy information about it, there was no mention of those 2 additional positions, and I thought that those positions were intended to help with some of that ADA compliance and those sorts of things. So I wasn't sure whether the report was generated before the positions were filled and staffed, or was that an oversight, or do you, so just fill me in on those 2 positions, please.
Mr. Chairman, actually there were 3, thank you very much. One was data trainer, which was to help the clerks in the courts out around the state to input data in a consistent manner, because we realized that now that we had this great electronic case management system, it would only be able to provide the data that we need if the input was done in a consistent manner. So that's one position. The other position was for a person to help with the maintenance on all our courtroom technology. And the third position was for a senior legal staff person in court administration. The court automation tech guy, that position was filled as soon as it was authorized. The other two are still in the process of being filled. I think we've finally, like the sheriffs, and seems like everybody else in the country, finding qualified people is a challenge. I think that we have people ready to start in the senior legal advisor and the data trainer positions, but they have not started yet.
Ms. Butler?
Good morning, Mr. Chairman, members of the committee. My name is Elisa Butler. I am the State Court Administrator for the Wyoming Judicial Branch. And Mr. Chairman, I know that you have a hard stop at 11:30. I want to be mindful of your time. And I'm not sure how you would like me to proceed. I'd be happy to walk through the position requests that we're making. I know that you all received a document that outlines those requests. I'd be more than happy to give you a little more detail and walk through each one of those positions and why we think they're necessary. But again, I'd like to take my direction from you.
Yeah, why don't you just walk us, to give us a quick overview of those positions and what the budget implications are?
Sure, Mr. Chairman. So the first position on your list there is a grant writer and grant manager. So within the judicial branch, we have never had a position that does grant writing or grant management. I think a lot of executive branch agencies have someone to help with this. We do take advantage of grants as much as we can, but some of the grants that can provide more financial assistance to some of the initiatives of the judicial branch require a lot more work. So a lot more grant management, there's a lot more reporting requirements, and this would help us to really look for and investigate grant opportunities out there to help fund the initiatives of the judicial branch without having to request additional general fund money. So that's the first request there. The second is actually two positions, and that would be for our software applications division. So within the Administrative Office of the Courts, we have 5 divisions. One of those divisions is software applications. So you heard the chief talk about court automation. So implementation of a case management system, implementation of an e-filing system, jury management system, e-citations. All of that work falls within one division within the Administrative Office of the Courts, and that's our software applications division. Those are multi-year projects. For instance, we are getting ready to wrap up the implementation of a case management system in the district courts. That process began in 2016. It will end at the end of this year. So that just gives you an idea of how big those projects are and how multifaceted they can be. And so these positions would be additional staff for the software applications division in order to help with those kinds of projects. So we're looking at 2 different positions there. One would be someone to help with kind of project and contract management. As you can imagine, those contracts are very complex. Keeping track of timelines and deadlines for the vendors are really difficult. And then also just making sure that we're keeping the projects on time, moving them forward efficiently, and then addressing any issues that come up along the way. The second is just another support person for that team. That team, in addition to implementing those large court automation systems, it also provides help desk support for the entire branch. So this additional position would help with things like help desk. When people have questions that they need answered in a timely manner, that would be a position there. Mr. Chairman, I know we're getting close to time. Trying to be mindful. The next is an HR employee for onboarding and offboarding. So as the chief mentioned, we support over 300 employees, which includes justices and judges throughout the state. And so that includes a lot of onboarding and offboarding, paperwork, benefits. We have an HR manager, which is a high-level HR person who spends at least half of her time doing these kinds of non-discretionary tasks. It's not really useful or the best use of her time to be doing these kinds of tasks. And so if we have somebody who could come in and do that kind of work, it would free up her time to do some of the more high-level things, such as looking at secondary trauma programs, determining if employees are happy, figuring out how to help improve the morale of the branch and the employees within the branch. A public information officer, I'm sure you all are familiar with that. One of the things that we get pretty often, and the chief actually right now acts as our public information officer for the most part. So we get public information requests quite often from the media. We also get requests for data pretty regularly. And so this person would help to coordinate the message of the branch and also to be the one that is working with the media and other entities as we move forward and try to educate people about the judicial branch. An education coordinator. So we actually have this position now. It is an ARPA funded position. So that funding will expire at the end of 2024. And so with this position, we would just like to have a permanent position. This person has been incredibly helpful and useful in educating the branch and also creating content for a learning management system, which allows judges, clerks, other judicial branch employees to get online learning courses without having to go to a live session. Very useful for judges who are very busy. The next, Mr. Chair, is behavioral health services employee. So as the chief mentioned, what we're seeing in our courts is a lot more behavioral and mental health issues. And as we move forward, what we've recognized is that's not something we can ignore. Judges no longer can just call balls and strikes because they are experiencing and encountering people with behavioral mental health pretty much daily. And so we have a couple of initiatives we're working on right now. As you know, last session, the legislature passed a bill to transition the administration of treatment courts from the Department of Health to the judicial branch. We will get one position with that transfer. There is one position within the Department of Health. And so that's one of the big initiatives. The second big initiative you'll hear about here in a moment is a diversion pilot program we're working on in Campbell County, which would divert low-level offenders with mental health issues away from the judicial system and into treatment. Both of those are big projects. And right now, you will hear, if we have time today, from our chief legal officer, who is Ben Birmingham, who's also our director of Chancery Court, and he is the one leading those charges. And so really, it doesn't make a lot of sense for our chief legal officer to be overseeing those projects. So this position really would be a position to help oversee the mental and behavioral health initiatives of the court. Court services position. What we heard as we worked with the National Center for State Courts is that many administrative offices across the United States have a court services office. And that is a place where all of, basically a hub of information for judges, for clerks. If you have a question, this is the person that you call. They're going to get you to the right place. So that could include a variety of different tasks. Some of the things that we've thought about is jury management, not necessarily at the district court level, because that is left to the district court clerks who manage the juries at the district court level. But at the circuit court level, certainly we could help the clerks with managing those juries. looking at forms. And so one of the things that we know we're working on a project we're working on right now, and something we know we need to improve, is forms for self-represented litigants. And so that's something that this position could work on. Also, working with county commissioners on a number of different things that seem very mundane, but judges take their time to do this. And that is like making sure they have furniture, working with the county commissioners on courthouse remodels, working on things like security. So all of those would work within this court services position to be that hub that judges and clerks could use. Mr. Chairman, I've got two more. Okay. The court navigator position. So we are looking right now, one of the initiatives of the branch is to pilot a court navigator program here in Natrona County. The court navigator program really is designed to help self-represented litigants navigate the court system. It would be a non-lawyer. And so the court navigator really would be a person, if you're a self-represented litigant, you could come in, you could talk to this person, and they could say, this is the form you need to file. This is when you need to show up to court. This is how you should address the court. This is how you should behave. This is how you should dress. And then help them navigate that court system. What we're seeing in the courts throughout the state is that there are more and more self-represented litigants. It's a drain on the court docket. It's also a drain on the clerk's offices because unfortunately they tend to be put into the position of having to help people navigate, and that's not within their role generally. You know, they're not there to help somebody navigate. They are there to help and provide as much assistance as they can, but they're not going to sit down with a litigant and tell them how to navigate the court system. The last position is the Chief Information Officer. I mentioned before the way that our office is structured, we have 5 divisions. One of those is software applications. The other one is our IT division. So our IT division handles things like cybersecurity, hardening the judicial branch network, does all of the equipment for the branch, so all of the hardware. And so in most administrative offices, and what you have on the executive branch side is you have a chief information officer. So the CIO is the person who oversees both houses. He oversees software applications and the IT side and kind of brings those together. In the judicial branch, we don't have that, mostly because we have 2 very, very strong leaders of each of one of those divisions. And so what ends up happening is I get to be the CIO. I think I do an adequate job, but I can tell you that someone who has some technology experience would probably be able to do that job much better than I could and foresee some of the issues coming down the road. So, Mr. Chairman, that's a description of the positions. If you need more information, I'd be happy to come back.
We will see you after lunch. Thank you.
Thank you, Mr. Chair.
We will adjourn for this morning, and then we'll go on our tour of the Townsend Building. We'll resume at 2 p.m. this afternoon. Thank you.